Stop. List this matter after 2 weeks.
2 weeks.
2 weeks on a date to be fixed by the registry along with the additional affidavit supposed to be filed by the petitioners.
Right. Obligation.
May it please your lordship,
Yeah.
with the consent of the other side, I'd beg to mention item number 7 and 8.
7 and 8.
Yes, lordship.
There was also a request from this court that when you go for, you have given that.
Yes, your lordship.
But why 2023 matters you are taking?
Your lordship, the arguing counsel is an outstation counsel, so I've submitted an adjournment slip that day, your lordship, as he has some personal difficulty. We have filed an affidavit in reply.
You have filed it.
Yes, your lordship.
An adjournment slip has been circulated on behalf of the counsel for the petitioner with a request to take up the matter on some other day as the arguing counsel who is from outstation is not in a position to appear today. Stop. List this matter after 2 weeks on a date to be fixed by the registry. So and so, you are paying the taxes, so and so appears for the respondent taxes, yes.
Your lordship, if convenient, your lordship may fix a date, your lordship. On the
Doesn't
weekend.
happen, we are only taking up those matters which are somewhat older than 2022, fixing a date.
Yeah.
Other matters, we are giving a week. The date will be fixed by the registry.
Okay,
We've said after 2 weeks on a date to be fixed by the registry, you make an application, they'll fix a date.
okay. Your lordship, there is an interim order.
Interim order passed earlier shall.
Much obliged, lordship.
May it please this, my lord. My lord, with the consent of the other side, I beg to mention item number 21 of the supply list, my lord. My
21.
lord, in this matter, our instructions are awaited, my lord.
You?
21.
To
the
do
supply
what?
list, my lord. 21, my lord.
Ah,
Our instructions are awaited. May I pray for fixing it on the next week, my lord. We'll place our instructions, my
anybody appealing for the
my lord. You have
petition?
the consent of the other side, my lord.
Mr. So and so, and the counsel appealing for the respondent. Respondents has submitted that the instructions in the matter are awaited and upon receipt of instruction, the affidavit of opposition will be
My lord, we
filed.
have filed, already filed. We have already filed our affidavit.
Then
the
what
last
instruction are you awaiting?
My lord, the petitioner had submitted one judgment that this specific matter has been covered.
Oh,
That
then you-
specific
then you-
matter.
then strike it the whole. It has been submitted on behalf of the learned counsel, it has been submitted by the learned counsel for the respondents that they are awaiting instructions from the department whether an earlier decision of this court in a similar matter would cover the case of the petitioners also. Stop. He prays for 10 days time to have his instructions. You can also go through the facts and find out whether it is applicable. 10 days time for the instructions, full stop. List this matter again after 10 days on a date to be fixed by the registry, by which time the instruction awaited shall be obtained,
My lord,
failing which the matter will be taken up for disposal.
oblige, my lord.
Please, your
Yes.
lordship, if I may be allowed to mention a case that has somehow been left out of the cause list
Ah,
today's date.
yes.
Lordship, WPC number 4499 of 20
Ah,
was last heard on 4th of November, 2 days
Yes.
back. Your lordship ordered that today we were supposed to submit the written argument, but somehow the matter was not
Oh,
listed
that
in the
matter
cause list.
where it will come in a production list. You have your written arguments ready. We'll
Yes,
take it
it's
today.
definitely, your lordship. Obliged.
It will come in a production list.
Obliged.
That senior citizen matter, your lordship. Lady Hart, your lordship, two questions whether, first question, lordship has asked about that. Whether the petition filed by the respondent number 2 under section 7 of the Maintenance and Welfare of Parents and Senior Citizen Act, praying for eviction of his sons from his self-acquired property is maintainable, as he had not sought for any maintenance, lordship. That was one question,
Yeah.
lordship. In respect to this, lordship, I have cited some decision of the Honorable Delhi High Court, lordship.
Mm.
So,
So on the last occasion, perhaps we had a discussion as to whether when the maintenance is not a part of the deal,
his application,
can this act be invoked?
yes, lordship. That was the first question, and
Ah.
whether 220, without, under 23 section of the Senior Citizen Act, Lordship, whether his application can
Hmm.
be considered. So Lordship, the first decision which was rendered by the Delhi High Court is Darshana, Lordship. Paragraph 3, your Lordship will find the same question, Lordship.
Darshana Das.
Yes, Lordship. Versus Government of NCT of Delhi, Lordship. The case of the appellant before the learned single judge as canvassed by her counsel was that petition filed by Dhaniram for eviction was not maintainable as Dhaniram had not sought for any relief of maintenance under section 4 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007, hereinafter referred to Act of 2007, and that getting rent from the shops on ground floor of the property. He did not require any maintenance, and as such, the claim for eviction without maintenance was not maintainable.
How was this dealt with?
Lordship, Delhi, there is an amended rule, Lordship, that is cited in paragraph 12, Lordship. But in this decision, there are some other high court's decision was also discussed. And it says that even in under a writ jurisdiction, Lordship, eviction can be sought by the senior citizen, Lordship. So,
No, but you
They-
did
they-
not seek it under the,
No, Lordship,
You
I am
went to the
seeking
wrong
the-
forum. Our only issue is,
Lordship,
with all sympathies at our disposal,
Lordship,
the petitioner may have a case for the relief he is praying for. The appropriate forum which he had to approach. That is the only problem.
under this act, Lordship, the tribunal is the appropriate forum, Lordship. Whether
Para
without
12, where did you say?
para 12, Lordship will find that is the amended rule of the Delhi, Lordship. The said sub-rule has undergone an amendment in the year 2017 to the following extent.
I am not being able to find it.
After paragraph C, Lordship,
Paragraph 3,
6,
6, yes.
Tanipal was discussed in paragraph 6.
Hmm.
And after that discussion, Lordship, there are some cross marks, Lordship.
Mm-hmm.
The said sub-rule has undergone an amendment in the year 2017 to the following extent. A senior citizen parents may make an application before the Deputy Commissioner, District Magistrate Office, District for eviction of his son and daughter or legal heir from his property of
Hmm.
any kind, whether movable or immovable, ancestral or self-acquired, tangible or intangible, and include rights or interest in such property on account of his non-maintenance and ill treatment.
Hmm.
My case is, Lordship, ill treatment. There
But,
is no question of maintenance, Lordship.
This is a
In
amendment to
respect
the
to-
rule of what? Which rule? Delhi maintenance of welfare. Do we
Lord-
have a similar
But
provision?
this court discuss some other decisions also, other high courts, Lordship. In paragraph 21, your Lordship will find. In para of Justice Santi Swarup Dewan,
Hmm.
this is Punjab and Haryana High Court decision, Lordship. It cannot be said that in such a situation where respondent number 7 was at best living with the permission of his parents, similar to like my situation, Lordship, which permission stands long withdrawn, the appellants and more specifically appellant number 1 should be compelled to knock the door of the civil court and fight a legal battle to obtain exclusive possession of the property. We are discussing about the son's case, Lordship. This would defeat the very purpose of the said act, which has an overriding effect over any other enactment in view of section 3 of the said act. In fact, the civil court has been precluded from entertaining any matter over which jurisdiction is vested under the said act and specifically bars granting any injunction. Respondent number 7 is thus LPA number so and so required to move out of the premises to permit the appellants to live in peace and civil proceedings can be only claim thereafter if respondent number 7 so chooses to make in respect of the property at Chandigarh, but without any interim injunction. It is not the other way around. The respondent number 7 with his family keeps staying in the house and asking the appellants to go to the civil court to establish their rights knowing fully well that the time consuming civil proceedings may not be finished during the lifetime of appellant number 1. In fact, this is the very objective of respondent number 7. Further, in Jayantaram, in section 23 was discussed in paragraph 22, Lordship. This is Gujarat High Court decision, Lordship. It, however, appears that respondent children are not taking sufficient care and are not providing proper and sufficient maintenance for the respondent, and that therefore, so as to maintain himself, the respondent needs sufficient earning income whereby he can maintain himself and provide for his own food, clothing, medical attendance, and treatment, etc. Therefore, the respondent asks the petitioner to hand over the possession of the part of the premises property wherein the petitioner is staying with his wife. However, the petitioner declined to hand over the possession of the part of the premises which is in his possession. In view of such conduct and action of the petitioner, the respondent was compelled to file the application wherein the authority passed the impugned order. It appears that in his application, the respondent requested the authority to take appropriate measures as per section 23 so as to get the possession of the part of the premises. The petitioner opposed the application and has now challenged the impugned orders on the ground that the same are beyond the scope and purview of section 23. Emphasis is placed on the expression transfer of the property in the said provision. It is claimed that the respondent has not transferred the property in his favor and therefore the provision would not be applicable and could not have been invoked.
Is that
In
correct?
similar to our situation, Lordship, there is an argument by my learned friend that as the property was not transferred in favor of the sons, Lordship. So the section 23 is not applicable in our case.
But then they go on to discuss section 4 at paragraph 15.1.
Lordship. It is noticed earlier that subsection 4 of section 4 provides inter alia that any person who would inherit the property which includes right or interest in such property and is in possession of property shall maintain such senior citizen which includes the needs of such senior citizen to lead normal life. So it is not the object of the act to only obtain maintenance, Lordship. 15.3, your Lordship will find there is no provision in the act to suggest or to indicate that the said term carries very narrow and literal meaning so as to mean only actual transfer of title and ownership and the concept of possession, which is recognized by the act, particularly under section 4 of the act, has to be kept out. An overall consideration and having regard to the provision under section 2B, 2D, 2F, 4 and the object of the act, the said term should receive wider meaning so as to include possession, occupation of property as well.
Yes, we have seen that. One Delhi High Court has gone ahead to say that giving a liberal and wider interpretation to the word
Section
transfer,
Lordship. Even if
allowing someone to remain in possession will also come into the ambit of the word transfer, and therefore, because of the transfer now, they can be said to be.
yes, and without even considering any consideration, they are allowed to occupy my premises, Lordship. The possession may not require legal transfer with a consideration amount, Lordship. If only I permit them to occupy my,
So their position, they are holding the property and using it to their likes and all.
only with
Would
my
be
permission.
lawful possession if not legal possession.
Yes,
That is what
Lordship.
you are saying.
When I,
It may not be on paper,
Lordship,
but it is not something that he is entitled to. What
Lordship.
is being allowed by the father to do with an expectation.
When
of
I allowed
maintenance.
them to occupy the premises, it is with my consent.
Huh.
When I withdrawn my consent, then it becomes illegal occupier, Lordship.
And then,
And if they want to claim their legal right, that they are son of the.
not during your
husband,
lifetime.
If they want to claim any right, then civil court. Then,
But they cannot do it during your lifetime.
yes, Lordship. And if they want to say that I will inherit this property, Lordship, in your absence, I will inherit this property, so I have a claim over this property. Then also they have to.
May
go-
not inherit, only if it is without a testament, then they will inherit. If he gives it to some donation to some mandir or some
That
masjid or some
discuss
other place,
that
there will be
even
no.
if the son and legal heirs claim that we will inherit this property. This is inherited by the
That
father.
is not a right which can be established in court.
For that, they are directed to go to civil court. Lordship.
Even if they go, how can it be established that I should inherit the property? I can do what I want with my property, will be the answer by the father.
And in this regard, Lordship, all the decisions from the Delhi High Court, Lordship, Sanipal, I have cited as decision number 2, Lordship.
Sunny Paul is something which has been discussed in this Darshana.
Yes, Lordship. Almost similar discussions as Darshana
Hmm.
and Vinay Verma, Lordship,
Ah.
which gives the directions, the guidelines in the act itself, Lordship.
Hmm.
After Vinay Verma, Lordship, that was in respect to DB Act and this Senior Citizen Acts, Lordship. Vinay Verma also, Lordship, will find that is on the basis of this Vinay Verma, Lordship, these guidelines were formulated in the act. Paragraph 3, Lordship. The conundrum gets more complex with the enactment of the PSC Act. This is Senior Citizens Act.
Which
Lordship.
paragraph are you?
Paragraph 3, Lordship.
Hmm. Mhm.
The conundrum gets more complex with the enactment of the PSC Act, Lordship. Paragraph 3, which permits senior citizens and parents to take proceedings for removal of their children from the house, which exclusively belongs to them under the definition of maintenance. And thereafter, Lordship, DV Act and PSC Act was discussed by this in this judgment, and guidelines were given in paragraph, Lordship. Guideline number 5, Lordship, that was already in the act itself.
Where is it? Page what you are reading?
Lordship, that is
Paragraph 45.
yes, Lordship. Yes, para 45 in while discussing Taruna Batra, Lordship. Last lines, Lordship. The question then arises as to whether the obligation of providing the shelter or roof is upon the in-laws or upon the husband of the daughter-in-law, that is the son. Some broad guidelines as set out below can be followed by courts in order to strike a balance between the PSC Act and the DB Act. Number 5 is, Lordship. In case the son or his family is ill-treating the parents, then the parents would be entitled to seek unconditional eviction from their property so that they can live a peaceful life and also put the property to use for their generating income and for their own expenses for daily living. And in our case, Lordship, in my petition, I have the father raises some allegations that he was ill-treated by the sons and his family, Lordship.
And his only case is that unless there is a transfer of the property, then the act will not come into play.
Which
Any
condition?
kind of maintenance was.
Condition.
With condition, the transfer has to be with the condition that you maintain me, unless the person does not transfer the property with the condition, then the children with their children, if required with their children, can continue to live in the property. The father cannot do anything. That is your contention.
Yes, beloved. Beloved,
Under this act.
Gist of the thing is that unable to maintain. And second the thing is that if transfer is with condition, that he will maintain me.
You were showing us some judgments. Where were
Yes,
they?
my lord, as Bonita, that Supreme Court judgment will.
What does the judgment say? Let us read again. I forget the exact.
Yes, I have.
Judgment kita disile copy kita Medio judgment kita man disile copy kita file ni. Itu na yun. Yes, we close the judgment.
Yes, Bonita.
Yes, Vanita, what does it say?
In this case, my lord, there is a clash between DB Act and this Act, my lord. And my lord, the father-in-law has filed an application
Hmm.
against his son
Hmm.
for eviction from the property. From eviction of the property, so that the daughter-in-law cannot take the property which she could get through DB Act. my lord. This was the
Hmm.
my lord, yeah.
ঠিক.
Now, my lord, one question was put. The question was put that the tribunal doesn't have jurisdiction to pass an order of eviction, my lord. In that context, my lord, it is, my lord, at paragraph 17. The Supreme Court has observed, my lord. May I read, my lord?
I'm reading para 11.
11, okay. From 11 onwards.
Then you were at paragraph 17.
17, my lord.
Hmm.
The substance of subsection 2 of section 23 as submitted by the second and third respondent is that the tribunal had the jurisdiction to pass an order directing the eviction of the appellant who is their daughter-in-law. According to the submission, the power of to order eviction is implicit in the provision granted in a right to receive maintenance out of an estate. And the enforcement of that right in supporting the submission, they have referred to the view which has been taken by several high courts indicating that the tribunal may order eviction of a child or relative from the citizen.
Hmm.
The tribunal under the Senior Citizen Act 2007 may have the authority to order an eviction if it is necessary and expedient to ensure the maintenance and protection of the senior citizen or parents. Eviction, in other words, would be an incident of enforcement of right of maintenance and protection. However, this remedy can be granted only after adverting to the competing claims in the dispute. My lord. Now, my lord, Honorable Supreme Court has said that it will be incidents, my lord, of maintenance. Only then. If your lordship,
So your clients say they do not have any liability under the law to maintain the parents.
yes, so far
There is no liability on the children to maintain the parents
under this act, my lord, because
under whatever act. Is there a liability to maintain or not?
if he is able to maintain
Whether he is able to maintain or not will be another part of it.
my lord,
We are on the liability of the children to maintain the parents. The expectation, just as the children have an expectation, my father will not throw me out. Would there still be an expectation on the father that my children will also maintain me?
yes,
The converse.
and this is a three judges bench, my lord.
Just a minute. Yes, what is your right to be in that house? What is your right to claim that you can remain in the premises owned by your parents? What kind of a right do you have?
If
We, for the time being, we let go of the respondent's application and everything. Kindly show us what right you have to remain in the father's property. Apart from the legal, the question of law which is now before us, apart from that, what is your right to remain in the property? Because your Supreme Court judgment would come to your aid if and only if para 20 is satisfied. Would be conclusive of an intent to deprive a woman who claims a right in a shared household. In this particular situation, what the Supreme Court had found was the son buys properties, transfers it to the father gives it to the wife. Now the daughter-in-law says that I have a right to be there because of the Domestic Violence Act. They cannot throw me out of the shared household. Now the father and the mother say that it is our property, push her out. Supreme Court says no. The very act of the son buying it, transferring it to the father, the mother getting it, and now trying to deprive a married woman, a woman married into the family, of her rights under the Domestic Violence Act will not be curtailed by the Senior Citizens Protection Act. So there the interpretation given that there must be a liability to be maintained, whatever sentence you have, it has to be an incident of the maintenance. The daughter-in-law is never in the usual course held to be liable to maintain the in-laws in the presence of the son. But the senior citizen can claim maintenance against the son. That's a right given by the law. Now show us some law by which a son can claim a right to stay in the property of the father. Then we can say to your advantage that the son has a right under a particular act. Therefore, the father cannot use the Senior Citizenship Protection Act to ask him to leave. Otherwise, what the Delhi High Court has said is influencing us. It is persuasive value and we are being persuaded to some extent.
in Delhi High Court, that
No,
Guidelines
you
like-
stick to the original question. Delhi High Court will discuss later.
Yeah.
Show us something for this Supreme Court Act to be read by us, this Supreme Court judgment to be read by us. Show us something that you have a right to be in the property of your father. And that is the right which cannot be now repelled by your father by merely depending upon the senior citizen. There must be a right pre-existing to you under some act or under some law, some custom, something which you would have tried to enforce, and at that point of time, your father comes out with this divine idea of using the Senior Citizenship Act against you. This is a case where the daughter-in-law was tried to be deprived of her rights under the Domestic Violence Act by the parents of the son, who transferred the property to the parents so that the daughter-in-law could be shoved out. It's a completely different context. And therefore, any observations made therein, we have to read with that context, not with this context. And if you have to take up this judgment, then you have to answer the right that you have, that you claim to be in the father's property, which the father is trying to use by the use of this particular act, trying not to let you use. That is not there. No son has a right to say that my father has to let me live there unless there are special circumstances. I am mentally incapable, physically incapable, I am so and so, I am so. Family. You are simply saying my father's property, wrong use of a wrong act. No, I will not leave. Can we shut our eyes to such situations? So now since you are using the law, we use the law. Tell us the right.
The right of the
If you
son.
cannot show that there is a right in you to stay in the property, then this judgment will not be applicable to you. Then the liberal and broad meaning given by the courts to the
Courts.
act of transfer, the definition of transfer, which would also mean allowing you to use the property, allowing you to be in possession of a certain part of it.
Hmm.
That is what will come into play.
But for that, I have to go through Hindu laws,
Done.
my lord.
This is of 2025. You had an interim order. We kept it as part heard.
My lord,
We raised specific issues,
my lord.
specific judgments. We do
My-
not keep it part heard any
My
further. This way, that way.
Only 3 days,
This way, that way.
only 3 days, my lord. Because if I have to see,
See, you had made your case.
my lord,
We raised queries to the respondent.
my lord.
You need your queries. These judgments are already on record somewhere or other. I have seen there also, perhaps copies are there. This judgment was handed over on the last date. We are simply trying to understand the judgment. Why do we need further time? If you have a right under the law, just tell us that, yes, under this act or under this thing, I have a right. And we proceed then. But if you cannot
For that
cite,
purpose, I have to see the Hindu law, because if your lordship asks me what is the right of the son, then I have to go through the Hindu law. What is there? Any custom is there or not?
then again,
But-
you'll be, again, we'll just be giving you time for nothing, because
My lord,
in the case cited by you, the daughter-in-law had tried to assert her right. And
But-
that is when the father and the mother of the son, they invoke this right to say that, no, we'll stop her by using this. In this case, you have never asserted your right.
well, that is there,
Can we
but
turn the clock back?
my lord, in this case, if we go through this, that judgment, paragraph from 11 to 17, my lord,
Which one? Which paragraph?
that as Banita,
Huh?
as Banita.
Yes, Vanita, when the circumstances are different, so
My
should we
lord,
look
of
into all
course,
those 11 and
but in
17?
that case, my lord, specifically,
What?
court has discussed, if you come at paragraph 11, dealing with the issue of
Mr.
jurisdiction,
Sahu,
my lord,
I think it is too late in anyone's career now to try to explain to you that if the facts are different,
my lord.
should we be going round and round in the observation part of a judgment?
But,
The facts are totally different.
this judgment is, my lord, purely on the, my lord, total explanation of the act, my lord.
No.
Total
It
explanation of
says
the,
the act will not be used by a senior citizen to stop. And even this circumstance, unfortunately, was also discussed in the earlier case. Which case? Darshana. Please come to Darshana.
that's not, you know.
Was it on Darshana? No, not on Darshana. It's the whole. It's- Just read it. Not Darshana, sorry. Vinay Verma. Come to Vinay Verma. Vinay Verma, para 4. Can you read the special categories of disputes? First category are the ones where the parents-in-law develop acrimony either with the son or daughter-in-law jointly and or individually, resulting in the parent-in-law seeking the right of exclusive residence either in the form of possession, an injunction, or seeking eviction of the son and daughter-in-law. The second category of cases are also there where there is a rift between the son and the daughter-in-law and either in collusion with the son or otherwise. an attempt is made to evict the daughter-in-law, this particular Vanitha case, your Vanitha case deals with the second category, where either with a collusion or without a collusion, the attempt is to throw out the daughter-in-law, stop her from using the premises. So there was a clash between two acts. The protection of women from domestic violence, her rights under that act, and the rights of a senior citizen. In that context, the Supreme Court says that when the daughter-in-law has a right to be in the shared property, that right would override the senior citizen's right to evict her, because the daughter-in-law requires protection and her staying in the household is not going to harm anything for the senior citizen. It is in that context Vanitha has come. In a context where the son says, I will not go out. Father says, you don't maintain me, go out. Does Vanitha apply?
Can it be at 2
So
minutes?
let me take a call. Let me take a call. And if agreed, let a larger bench take a call.
Well, at 2 minutes.
Huh?
At 2.
2 may not be possible because I have a bench at 3 again and I have some work. 2 may not be possible.
What day, Milord? Tomorrow? No
Huh?
problem. Milord. Tomorrow.
I think we'll keep it for delivery of orders. You have any more judgments to cite?
Okay.
I can ask you to file your written arguments in 4 days' time. And
My God.
thereafter, we'll deliver the judgment. Hearing is concluded.
My God. But no, Milord, a date be fixed, Milord. If tomorrow, Milord, I'm not seeking more time, Milord. Tomorrow, if not possible, tomorrow on Monday, Milord, okay.
Kaile kita আছে? Kaile kita আছে? মানে fixed date দিছিলে কাগজখন মই এটা বাৰে বাৰে থৈ যাওঁ বাৰে বাৰে হেৰাই লৈ ফুৰিবলৈ। Any process of 2 items, no?
In S. Vanitha, your lordship will find she was given 1 month time to approach the appropriate court under DB Act, lordship.
What we find is that in Vanitha, it was a clash between the right of a
Wait.
daughter-in-law to stay in the shared household versus the father-in-law's attempt to evict her using the senior citizens.
Right.
That was the only clash, and that was
Right.
explained by the Supreme Court.
Lordship,
That is how we are understanding it. He wants us to understand it some other way.
lordship.
We cannot say no today itself, so we are.
Says lordship, it can be evicted under this act, but
Mm.
as she has a right under 2005 act, so there is a clash, lordship. So in last paragraph, in order to enable the appellant to pursue her remedies under the PWDB Act findings, lordship, that is summation F, paragraph 24, 4, lordship.
Hmm.
In order to enable the appellant to pursue her remedies under the PWDB Act 2005, there shall be an order and direction restraining the respondents from forcibly dispossessing the appellant, disposing of the premises, or from
Where are you reading?
last paragraph, lordship, that is 24. Summation.
Ah,
24, 4, lordship. The eviction order was set aside by the Supreme Court, but in last paragraph 4, it held that in order to enable the appellant to pursue her remedies under the PWDB Act 2005, there shall be an order
that
and
is,
direct,
if you, what I was trying to say is now, that if you say at paragraph 3,
lordship.
paragraph 23, parallel to this, somewhere in the middle, parallel to this, the appellant had instituted proceedings of dowry harassment against the mother-in-law and her estranged spouse, and her spouse had instituted divorce proceedings. The appellant had also filed proceedings for maintenance against 4th respondents, and divorce proceedings are pending. It is subsequent to these events that the second and third respondents instituted an application. The Supreme Court had in mind that this is an attempt
To protect their
to-
son.
to protect the son and their property from the daughter-in-law with whom they were having series of litigation.
Lordship.
They wanted their protection, their property to be protected. Supreme Court said, no, the eviction order is wrong. Appellant will go have an order to be in the shared household or to remain in some other household at the expense of the respondents.
Only
Let her pursue that.
she was
But don't
directed,
throw her out now.
do not, Lordship disposes her forcibly.
Ah,
That is, dispose the appellant disposing of the premises or from creating any right title interest in favor of any third party in any manner whatsoever for a period of 1 year.
one.
Only 1 year time was given to her to approach the DB Act, Lordship. To enable the appellant to pursue her remedies in accordance with law, the appellant is at liberty to
Yes,
move.
heard Mr. S. Sahul and a counsel appearing for the petitioner, also heard Ms. Spencer appearing for the respondent, sole respondent. Petitioners or petitioner?
Petitioner, such F, my lord. petitioner.
Yes, petitioners.
Susan Raja.
And Ms. Spencer appearing for the,
What copy?
Ms. Harchodri appearing for the sole respondent. You are appearing for whom?
Respondent number 2, Lordship.
Who is the respondent number 2? Who is respondent number 2?
Who is the father?
Father, Lordship.
Where can you show us the? Yes, yes, yes. Oh, we have this before. That is why the we are taking up the. We have on our hand the IA. In the IA, we are not being able to place the rest.
Lordship. Father is the
It
applicant
can
in
be
the IA, Lordship.
This matter, the interlocutory application for vacation of stay was listed before this court on an earlier occasion also. And at the request of the parties, and with the consent of the parties, the matter was taken up for final disposal.
My lord.
The matter was heard at length on 17/10/2025, on which these certain queries were raised by this court, and the matter was fixed today. Stop. Counsels for both the parties have made their submissions. This Kamalakanto Mishra was given by whom?
By me, Lordship. 2025. My learned friend said that that is in some other factual, Lordship. There are some other.
No, we are just asking, and this
By me, Lordship.
Urmila Dikshit,
By me, Lordship. Kamalakant also by me on last occasion. Today I have cited 3 decisions, Lordship.
Achha, theek. And this Vanita is by the petitioner.
Right.
Any other judgment that you are citing?
No.
Vanita is the one you are declaring. Today
If I
also,
find next time,
tomorrow, we are keeping it tomorrow.
tomorrow, okay.
Uh,
In Lordship.
Today, both the councils have made their submissions, and at the closure of the hearing, Mr. S. Sahu has made a request that the matter may be taken up. Now, he may be allowed an opportunity to submit citations in a short time with regard to the issue. We'll list this matter again tomorrow at 2 p.m.
Lordship, may I submit
It
this is
is, yes.
Justice Shanti Swarup matter, read jurisdiction, their eviction was granted, Lordship. It was cited in Darshan, the Lordship. Delhi High Court cited this.
The citations are no problem.
Lordship.
Stop. Release this matter tomorrow at 2 p.m. कर दिया ना? But tomorrow we'll not go into lengthy arguments. Just one thing, we are just giving you the time to show us that if you have any right, as in Vanita, which she could place before some court. She had some right that she could place before some court to say that I have a right to live in that property. She could have made an application. Show us something that there is a clash of some two rights. The father's right to have his property to himself and the son's right to stay in the property without the consent of the father. That is the only thing we are going to do tomorrow. We will not go into any other lengthy arguments.
A little bit explain the money tax.
Give your written arguments on that. We'll consider
Tomorrow.
tomorrow. Thanks.
There is an interim.
Yes. Interim order will continue till tomorrow.
Published.
Yes, NHAI was required to have some instructions.
I have got some document there because earlier the council who was looking after the case,
Mm.
he expired, Lordship.
Mm.
So record was with him. So they have the given some papers, Lordship. That is one thing, Lordship. What happened in this case? They are claiming 15 lakhs per bigha.
Huh?
They have challenged they have filing the repetition only claiming 15 rupees 15 lakhs
Mm.
as a compensation.
Mm.
But they have not challenged the order of the district judge. They should have filed an appeal under
There's
section
an
36,
outstanding compensation.
not
Where
outstanding.
does that outstanding come from, sir?
The whole
In the
compensation.
repetition,
Yeah.
the prayer is that there is an outstanding
Because
compensation.
3,60,000 has been paid,
Mhm.
3,60,000 has been paid, the rest outstanding.
Where do we find that it is
Yeah,
15
in
lakhs?
in the record also, in the revenue.
That you should have been paid 15 lakhs. Where do we find that?
There is in the arbitration award.
Where is it award?
Even the arbitrator was made party personally minded, he has also given his objection to the district judge. How he assessed the rate of the land, value of the land.
The arbitral award was in his favor,
Right.
saying that the landowners would get 15 lakhs
But
each.
that was also that
You,
really
you filed a appeal against that.
that lordship,
In that appeal, you got it reduced against a particular landholder,
land lordship.
but not against all the landowners. So the award
Because lordship,
would
the
exist against him.
other land owners,
Ah.
they have not filed any case before for enhancement or nothing, lordship. They were satisfied with the 2.5 and 5 lakhs, lordship.
Where is that award?
The award is lordship at page 18, the district judge.
That 15 lakhs?
15 is the lordship, the arbitrator award.
Uh-huh.
14, page 14 is the,
Page,
sorry,
Page 11 is the
18.
money award. And that's
page
the one of the-
18 is the arbitration
Yes.
part.
page 11.
Uh,
The arbitrator,
who were the parties here?
the petitioner was not a party. Because his land record was not corrected by the competent authority. His name was not included in that DAG number, lordship.
It was his mother's land, my lord, because in the.
Mother's name.
My number. Father. Correct.
Mahadevi বেলেগ ল'ৰা ছোৱালী। Son of petitioner is the son of Karam Sethi.
Yes.
এটা লিখে উপাধ্যায়। সেতুর উপাধ্যায় কেনেকে হয়? হ্যাঁ? উপাধ্যায়। কেনেকে হ'ব?
Page 12, my lord. My name is there. This is the result of inclusion of the name land of Sri Ghansam Khetri under PP number so and so so.
Sorry, which one? Page number
12 of the award.
12. This as a result of inclusion of the land of Ghanshyam Chetri.
Yes,
This was overlooked earlier.
yes. Overlooked earlier.
But that should be corrected by the revenue authority, by competent authority.
How are you concerned? You are supposed to pay the amount of the land. Whom they release it to is their headache.
But he has no direction is there to give the competence to the, but he was not a party in this case. In the arbitration case.
And my lord, 3,60,000 has been part of compensation
Ah,
paid
that
to
3
me.
lakhs
Now
60,000
they are denying what
where
is.
did you pay?
One thing is there, I
Now,
have.
why did you pay the 3,60,000
Yes.
to him?
No,
Why did you release?
To 5 lakhs lordship.
Which one? Which 5 lakhs?
5
Where was it
lakhs was
given?
awarded to all the person lordship.
Where?
Yeah, of the same DAG number.
Where? By which order?
By
which?
district, by district's order lordship.
Where is the district judge's order?
Donest order.
Where is the district judge's order?
Page 18.
Page?
18.
So the moment you say that his land is there within that particular part, all the landowners that they'll get 5 lakhs each.
Yes.
The
all
moment
the
you say that
owners.
the land, his land is there and he was entitled to that 5 lakhs, you did not challenge the compensation being made in his favor for 15 lakhs. You challenge it for the others.
No, it is because he was not a party in that arbitration.
But he
case,
was in the
that's what happened.
arbitration award.
Now let us see this page 12.
Yes,
Yes.
yes.
This is a result of the inclusion of the land of Ghanshyam Chetri. Do you find that sentence, madam?
Yes. as a
Now
result-
in this court of the district judge Nagaon, kindly show us that it was also the land of Ghanshyam Chetri which was included here.
Later on, what happened, Lordship, his name in the
Okay.
award list
We are trying
published
to
by
under-
the, as per the National Highways Act.
See,
the award list has-
25/9/2008 is the award by the
Award by the.
Commissioner North. Commissioner North.
Yes,
Yes, 25/9/2008.
yes,
Page 12 of that order says land of Ghanshyam Chetri is being included here. Yes,
yes,
then this is appealed. An appeal to this order is made and the order is at page 18. Am I understanding correctly?
yes,
Just the facts. We are not on what
yes, yes.
we are trying to. Factually, we are correct till here now. In this page 18, the land of Ghanshyam Chetri is not there when you made the appeal. Am I
Yes.
correct in that?
Yes, because.
So you did not challenge it against Ghanshyam Chetri, although Ghanshyam Chetri's name is there in the original award.
No,
was there.
actually only an inclusion, his award, his name is not there.
So
Later-
once his land
As
is
per the
in,
report of the circle
let us
officer.
let us then read the last paragraph again. On the other hand, the construction of NH is being delayed. Appellants have applied for passing an order for interim award of 50% of the present market value. Considering the probable value of land per bigha at the rate 15 lakhs, 50% is hereby passed for payment. Total area of land being acquisition 6 bigha. Previously, total area of land acquisition was shown as 5 bigha. But during the fresh assessment, the circle officer found out that as per land record, the actual total area of land to be acquisition is 6 bigha.
6 bigha.
This is a result of inclusion of the land of Ghanshyam Chetri.
Yes.
Therefore, total amount of compensation on the land alone would be 95 lakhs or 95 what? 95 lakhs. Now, therefore, this award was very specific when it said
Lordship.
that originally 5 bighas, now 6 bighas because land of
One
Chetri
because
comes in, everybody gets 15 lakhs,
Yes.
50% of it to pay, please pay.
That-
You challenged this.
That is true, Lordship, but the land record was not corrected by the revenue, that authority, competent authority. His name was not included in
name-
the tag number. Later on, he has filed a application before the revenue authority.
Ms. Bora, we are not trying to convince you that that
That is-
appeal should have been also in his name. We are not trying to convince you on that. We are just asking you a fact. The name of Ghanshyam Chetri was there on
Yes.
in the award.
Yes.
During the appeal, it was not included.
Yes,
although it was there in the award.
only mention.
Now, just tell us, can he be denied or can this appeal order be made applicable on him?
Yeah, and later on, and separate award was published in
Where
his name.
Where is it?
A record is there, Lordship.
Show us that.
Yes. Page 20,
Page 20.
page 20 of my efficient opposition, Lordship.
You have to give me the running page.
I think their copy is not.
Oh, running, at that time, no running. 17,
Here it is running. Page
20, Lordship.
Ghanshyam Chetri, yes.
Later on, this award list was published. Later on, Lordship,
By whom?
by a competent authority. Because without publishing the award list, we
No.
cannot give him any compensation, Lordship.
That copy is not furnished along with the evidence.
Huh?
Count is not complete.
Which is
Annexures
not
are
com-
not there, only affidavit is there.
Sorry?
Annexures are not there in their counter. Only affidavit is furnished.
এটা আপনাকে at that time, who was prepared the Pradeep Kumar.
So therefore you are not in the, oh, he's been taken.
And
by
how can
surprise.
this, there you want a second award? Once the award is passed already.
Now, one award is already there.
Yes, that is final award.
That is a final award and now,
That is in the name of our.
just a minute, just a minute.
No, no.
Keep happening. Yeah, but
6 bigha total land, 5 bigha others and
very
1 bigha 9.
clearly. Lordship, then why
This,
this one?
this court will appreciate it so much if the councils do not try to answer each other directly. Because the situation does not then remain where we can interfere. And what is this, page 16 of your affidavit, madam? What is page 16?
The judgment photo of the arbitrator. To the evidence has been- To the-
When was the original 15 lakhs, when was it done? 15 lakhs,
As
for
the
that?
interim major Lordship.
Just a minute.
No, no, district judge is glad with this final matter.
25/9/2008.
15 lakhs, 50%.
How can there be two?
Interim order. Huh? No photocopy issue.
Yes, under what provision this new, who appears for the state? Now, we are just trying to clarify the matter. So that Mr. Sharma also has an idea because he does not have the annexures. We'll have a discussion, yes. On 25/9/2008, that award of the commissioner, North Assam Division, it says 15 lakhs interim, we take it to be 15 lakhs, pay 7.5 lakhs. And then this way there will be a final adjudication. Against this order of interim, they went on appeal. They got it reduced for some persons. What is the final award? Where is the final award? Where is the final award? Why are we fighting on the interim award? Because if you see at that order of 25th of September, page 11 of the writ petition, if you come to page 12 at the end, what does it say?
Order will not affect the final arbitration.
Where is the judgment? Because now madam is saying at page 20, at page 20, she is showing something of 2015 saying that yes, the award was reduced to 5 lakhs. Where is that order? Making it 5 lakhs. And if from the interim of 15, it has brought down to 5 lakhs, they must have had noticed, they must have participated, they must have contested, something must have happened.
Internally passed out.
They have participated, the other person, they have participated in the hearing, Lordship.
Other person, not me.
No, was the final arbitration
no.
award?
No, no, man, that was, it will be final by the District judge itself.
Where?
Same all page 18. The-
Page?
Page 18 of the petition. This corresponds 534 of the consensus.
Salary 25 lakh thousand.
Yes. For setting aside the arbitral award. That is what they have challenged.
Sir, 25/9/2008 is an interim arbitral, is an interim compensation.
yes,
thing. It's an interim assessment.
Yes.
There must have been a final assessment. Can it be without a final assessment? Cannot be.
Yeah.
Where is the final assessment?
There
That
is
is what
no
I'm
fi-
asking them.
This is my final one. This is,
How can it be?
that's what
Money
they have
to serve
done.
out-
That's what they have done, my lord.
And in fact, you have filed a rejoinder. How could you do it without the annexures?
ইলেকট্রনিক কোনায় চেক করে সব লিখে দিচ্ছেন পিন অপারেশন অ্যানেক্সন লিখে দিচ্ছে
লিখিয়ে দিতে হবে। মানে clerk বিলা কেনেকে?
district judge judgment lordship page 15 the other parties lordship with appeal
Page,
page 15 of my
Uh-huh.
pin opposition
page 15 is a written objection.
no page 15 is the judgment lordship of the district judge
Page 15 of what?
last 15 of my appeal
Your affidavit.
What happened in the arbitral award lordship? The Khakul officer were directed to actually they assess the to submit the report of the adjacent plot.
Madam, we will refuse to hear you now. We will refuse to hear any of the counsels in the matter now. What does page 15, where does it start? At page 12.
Page 12 lordship
Page 12 is a challenge to which order?
is a arbitral award
Which is the, it is,
passed by the arbitrator.
please find out what is, please read what is 25/9. 2 lines, 1 page before that. Second last paragraph, what does it say? This will not affect the final arbitration. If you refuse to acknowledge the fact that the appeal is against an interim assessment or an interim order, and you want to emphasize that this is the order, final order, then this court refuses to hear any of the counsels.
Unbelievable.
Let someone from the NHAI come down here with all the records of the final award, if they are not being able to explain to you.
I have asked them lordship this.
They are not being able to explain to you. So let them come down. With all the records of the award. DC also, you also come down. State, where is that award?
One thing
They are asking for payment of 50% of the interim assessment. 2017 onwards, this case is going on. We do not know where is the final award. If there is one. And we are fighting whether we should give them 50% of the interim assessment or not. When? December, second week? Do we need to quote down everything in the order, or would you remember?
Only why not the bill will come up with.
Not only, what we need to know is this. 2008, there was an interim order that was appealed from. That was in 2012, that order came.
25/2008 that has been challenged.
That was challenged and it was brought down to something in 2012.
1940.
Whether the petition is involved or not is another chapter. 2012, that interim was decided.
After that, what happened to the?
Now, if you have the affidavit filed by the NHAI, do you have that affidavit? Page 20, running page 41. You find that? Page 41, the first name is Ghanashyam Chetri.
Yes.
Now, Ghanashyam Chetri, you see the amount payable to the pattadar is 3,61,832. 3,61,832 is the amount shown at the end.
I'll come with the instruction, what happened to the my lord final regarding the case number 4.
No, there is another thing. At page 40, kindly look. LA case number 53 of 06. What is this then?
53, yeah, like it's.
Page 40, kindly show. Page 40.
Like it say.
At the top,
53.
reference. Huh?
53 of the 2006.
Subject.
Award list.
Where is it award?
In the award list, it is mentioned.
Huh?
Award list, it is mentioned regarding the land acquisition case.
This is your check given by the deputy commissioner. This is the check given by the deputy commissioner showing the check. Where is that award? If the final award has come, then your payment in the under the interim may require a relook. If it has been finally decided, this interim assessment will merge with the final assessment.
Yes,
This will all require a relook into the matter,
yes, sir.
whether
is
you can
true,
make
my
this
lord,
claim now or not.
But even the my lord, the arbitrator was made party, personal party by name in the.
All that will come up later on if there has been a final award. If there is a final
So
award,
far, I know, my lord.
Hmm.
So far, I'm concerned. There is no final award as such. And my
That-
lord, that is what they have challenged before the
that-
district judge. Otherwise, they would have challenged the final award before the
That-
district judge. They have not challenged
no,
it.
the check
is-
that has been issued to you in the year 2015, sir.
Yes.
That check is for an amount of 3,60,000 after deduction of the taxes.
Yeah.
So maybe the final award came down to 5 lakhs. Maybe. And therefore you are given a final payment of 3,60,000 in the year 2015, which you have not challenged in 17. If that final award is there, this petition has to go because it is a challenge to an interim assessment. This interim assessment will merge with the final
No,
assessment.
whether in
Challenge the
no,
final
yeah,
assessment.
whether in the final award, man, it was notice issued to us or not.
That is a question which we can decide once the final order is before this court.
Yes.
Not
no,
today.
Once the record is there.
That is what we are trying
Once
to
the
ask.
record
him.
is there, the final award is there.
That is what we are
Because
asking him to
So
bring.
far, I know, my lord, no notice, nothing was issued. Even the arbitrator does not say.
Sir, even the affidavits filed on grounds of knowledge don't inspire much confidence. So knowledge is one part. Let them bring the records.
Yes.
Yes, heard Mr. R.P. Sharma, Senior Counsel assisted by Mr. G. Bhutti.
Regional Commissioner Office at present is about this. It's been came up by the Secretary Revenue Department.
Ah.
So, but if Revenue Department has been made up for this case, it will be.
Ask someone from the revenue department to come. You are all the government.
I think.
Yes, have you understood what is going on? Were you here a few
The
minutes?
revenue
What
was
has
direct-
happened is this. We will ask
It is a
the
direct
parties to
command.
give you. We will ask the parties to give you all the documents. We are not making you a party as of now. What has happened is this. There was a land acquisition, there was an interim assessment and an interim order to pay a certain amount of compensation, 50% of the interim assessment. Interim assessment was at 15 lakhs. So an order to pay some part of it, 50%. NHAI goes up to challenge that part of the order. Does not make the petitioner a party. Without making the petitioner a party, the assessment is brought down to 5 lakhs. So far, so good. Checks in that order comes in 2012. Checks for 5 lakhs minus the TDS, 3,60,000 something is handed over to the petitioner also, who was not a party to the appeal. He challenges the entire action, comes before this court. Now, if the final award has been made, the interim award, that interim assessment merges with the final award. If the final award is for 5 lakhs, this prayer for grant of the rest of the interim compensation goes, doesn't survive. He has to challenge the award which was finally made. There is nothing on record to show that there is a final award or what was the final award about. If the final award is for 15 lakhs, he gets some money. If the final award is for 5 lakhs, this writ petition goes, he comes back with whatever relief he has.
It would be done by Kala.
What happened to that LA case is what we want to know. The deputy commissioner issued checks
Land acquisition.
based on what? In the year 2015. He says land acquisition case number so and so. So he must have a copy of the order. Huh? Before he issues the checks, will he not he have a copy of the order? By whosoever it be. Why should we go to this department, that department? The person who issued the check based it on some record. That record we can see. That this is the order which based on which. It will cut the long story short. If there's a final award, you give him the number, give him the date, give him a copy, finished.
But that record could be available in the CC. Is the computer.
So you are pushing it to revenue.
No, no. I'm not pushing it.
Every minute is going to cost another 10,000 from now on. Yes. Who is the authority?
What is the commissioner of Regional Commissioner? It has been
Ms.
approved.
Bora. It has all emanated from your affidavit, so you will not escape. Kindly show him page 40 again.
Is
Page 19 of your affidavit.
My lord, I'll do the needful, my lord.
And then additional deputy commissioner Tam Kala asking the Kala doing it, additional deputy commissioner not doing it because he is not now representing the revenue board. Things in the report. Same
My lord,
person holding different offices.
I'll do the needful.
Have you seen page 19?
Yes, yes, yes.
Who issues it?
DC.
Listen.
DC Nagaon. Based on what? This officer letter number so and so, you're sanctioning or the letter to NHS so and so. And on top of that, payment of compensation against
Yeah, land acquisition case.
LA case number 53 or 06. He must have read this document before he
Yes, yes.
signed the check.
First,
Whether on the basis of the final awards. But I think it.
And if there is no final award as of today, from 2008,
one thing is their lordship, the land was acquisition under the NH, National Highway Act. But additional 3G proposal was taken lordship.
heard Mr. R.P. Sharma, learned
He
senior counsel,
challenged
appealed. Huh?
before the arbitration.
Huh?
If he is not satisfied with the lordship, the proposal was a
Which
3G
one?
award.
Where is that award?
Yes, I have taken that additional 3G as per the.
Where is
land
that award?
Yes, yes,
What is the land acquisition case number?
At page
Page-
18.
yes, page 18.
So you give us a number. We do not know what is inside that. We do not what is that order.
I would try to. 3G award was published.
That order. That
Yeah.
is what we are trying to say. If an award is there,
Award is
all
there.
his interim relief granted to him will merge with the final award. But he has to know that there is a final award.
Land acquisition case lordship. Yes.
Till now it is 15,000. 1.5 minutes gone. Heard Mr. R.P. Sharma, learned senior advocate, assisted by so and so. Also heard Ms. R. Bora.
Okay.
Learned counsel is paying for the NHIDC.
No, NHAI.
NH,
National Highway.
NHAI. Also heard Mr. So and so, learned counsel is paying for the 2, 3, 4, 5.
And thus.
And
And thus.
us. And oh, you're saying your name. Your name is already. This writ petition has been preferred challenging. No, has been preferred
Land acquisition.
Or- directions to the respondents to release the compensation amounting to rupees 14 lakhs approximately as awarded by the respondent number 2 by order dated 25/9/2008 in case of in case number 4 of 2008 at the rate of rupees 15 lakhs per bigha along with interest accrued thereon. Today, when the matter was taken up and parties were heard, to some extent, it is seen that the order dated 25/9/2008 passed by the Commissioner North Assam Division was an interim order which had reflected that the order will not affect the final arbitration judgment if in any way, full stop.
to be,
Six.
Murio.
The NHAI had preferred an appeal against the order dated 25/9/2008, which resulted in the judgment dated 19/4/2012 to be passed by the Court of the District Judge at Nagaon, Assam. Full stop. In the year 2015, comma, as pointed out by Ms. R. Bora, the Deputy Commissioner had made payments in the name of the petitioner as compensation with regard to LA case number 53 of 06, full stop. Unfortunately, though the case has been pending since 2017, none of the parties have brought on record the orders or proceedings that have taken place in LA case number 53 of 06, full stop. In the opinion of this court, the finalization of the LA case number 53 of 06 would have substantial relevance to the claim of the petitioner, which is against an interim assessment and compensation award, full stop. Mr. N. Das, Learned Counsel, appearing for the respondent numbers 2, 3, 4, and 5, prays for a short accommodation, as does Ms. R. Bora, Learned Counsel, appearing for the respondent number 1, to have instructions from the client, from the respective authorities as to the fate of the land acquisition case number 53 of 2006, full stop. Allowing such accommodation, list these cases again on in the second week of December 2025, by which time either the appropriate instructions would be made available to this court. Yes.
Will place a record of the.
Ah. No,
LA
you,
case 53 of the.
you
Actually,
put
our
on in
case
the
is
form
like
of an
LA
instruction record, whichever way you want. Yes.
And our case is LA case 4 of 2008.
That is not LA case.
LA case.
That is not LA case. Is 53 of the case.
Also.
It's not that.
LA case no, the application, arbiter case number. The arbiter case,
This was a case before the
arbiter.
commissioner. It
Commissioner.
was numbered as case number 4 of
4 of
something.
8.
That is not LA case number. Yes, to this court, comma, failing which the concerned councils, the concerned incumbents holding the respective posts shall remain present before this court. Get us an instance.
My lord,
Yes.
The learned counsel appearing for the petitioner and assisting the learned senior counsel shall also make attempts to have their instructions in the matter. Yes,
well, there is no copy with her also of their affidavit, not with me.
yes.
So from the court matter copy will be kept to,
She will provide you copies within,
she doesn't have,
you also don't have annexures. No annexures.
no affidavit also.
Acha, it has been submitted by the learned counsel appearing for the parties that complete set of the affidavit in opposition filed on behalf of the NHI is not available with them. Full stop. The councils are allowed to have certified copies of the affidavit in opposition
Oh, no,
filed by
they-
the respondent number 1.
But there is copy, my lord.
No, let us read this. The learned counsel for the respondent number 1 shall obtain certified copies of the affidavit filed on behalf of the NHA and would supply such copies to the councils appearing for all the other parties in the matter.
My lord, let him, my lord, let him in part her, my lord.
Yes,
Part her.
within 3 working days. No, we are listing it in December. We do not
Pardon,
know-
my lord.
we do not know whether we are there or not.
But further hearing,
For further hearing,
my lord,
further hearing,
yes, for further hearing. Apply. December month, any date?
we are saying in the second week of December.
Second week.
Second week of December on a date to be fixed by the registry.
You do that.
Registry will do it.
Otherwise, my lord, it will never come.
Simple application does the work.
My problem is that lordship, the earlier council We has filed the affidavit, he has expired, Lordship.
What we do?
Take a certified copy, supply them copies.
Yes.
Yes, I will supply, Lordship.
If not the awarded amount, at least the affidavits that can be supplied.
It is act of
If
God,
the
my lord,
dis-
recording an
Original record can be find out, everything will be solved.
with the decision, Nagaon or
This is
decision,
against an interim compensation. I did not realize it on the last date. I must have overlooked it somehow.
Yes.
Otherwise, today we would have that finality. Yes, sir. The
My lord.
document has been-
My lord, in contempt, there is a, my lord, that amendment of cost title, my lord.
Done.
That contempt may be withdrawn, my lord. Contempt may be withdrawn.
Maybe withdrawn, or are you withdrawing?
Yes, I am withdrawing, my lord.
I cannot withdraw it.
No, I'm just
Where
making
is the
suggestion.
contempt case? Contempt case?
So, my lord, the amendment of cost title is not required, my lord, since if the main contempt is withdrawn.
Mr. B. Sinha Learned Counsel, contempt to liquid. Learned, B. Mr. B. Sinha Learned Counsel appearing to the petitioner has submitted his instructions not to press the present contempt petition in its
Ye-
present form,
Yes,
and he prays for permission to withdraw the same. Permission granted. Contempt is closed as not pressed. Yes.
yes.
Now, 18,
My lord,
elected 23, period gone 20.
Yes, yes, I know. My lord, next week may be taken the hearing, my lord. Next week, my lord.
Just tell us, 18 elected, 23.
But my lord,
finished.
2 times they have, that's why contempt is filed, my lord. In spite of stay order, they have appointed one-man committee.
Who was
Yeah,
not, who
yes.
was not allowed to act.
No,
How
no.
let there be a face look?
Later on, when we have filed the writ petition, then only it was against stay. For 2 times.
Hmm.
That's why contempt filed, my lord. Not for 1 time, 2 times.
No, what would be the final result of the repetition?
No, writ petition now time is expired. It's
Then-
of course.
Then what,
That's why, my lord,
what do we adjudicate then?
no, adjudication in the department, there 2 times they have appointed one-man committee. That is the thing. One-man committee, there 2 times. So
Let
sometimes, my
Let
lord,
let us assume that was wholly wrong.
as a whole.
What is your relief?
Because now our society
So
did not,
that part you want an extension.
no, that part, it cannot be done,
Cannot
my
be,
lord.
then-
Cannot be done.
Then
But the thing is that, my lord, that period, my lord, nearly 2 years period, the society could not be functioned, my lord.
true.
Could
What,
not be functioned because
what
they
is the-
don't do anything, my lord, because one-man committees, they said they we have got the stay order.
no, Mr. Sinha, just tell us this. There are so many complaints in this world which does not have an answer or a relief.
Yeah.
Now, you were elected in 18,
Of
23.
course, but the tenure is expired.
We did not interrupt you. Listen to us.
Tenure is
23
expired.
23, the tenure expired.
Yes, ma'am.
25, we are sitting here. Why keep the repetition pending is what we are asking. What relief will flow?
No, relief to now relief, I cannot
Let us
seek any
proceed.
relief, my lord.
If you have got any other relief to seek for, you would have the liberty to come
No,
in and
this is
approve
that
an
the
application.
body, no, that now since one-man committee is stayed, my lord, only relief is that we may be allowed to, my lord, conduct the election. That much only, my lord. We may be allowed to conduct within a, whatever time, my lord, your lordship, my lord. That
We
may be,
will-
that relief may be
We
given.
will allow conducting of an election as is provided for in law.
Now, because to conduct the election, actually, when the body is expired, automatically 41(6) comes.
So who,
That government officer would be appointed and he will conduct election. But the
That is the
relief,
process.
whatever, if your lordship, my
that
lord,
is the process. We would not like some person who no longer holds office
the
to stand
process,
up.
of course,
Yes,
since,
take down. Heard Mr. B. Sinha, Learned Counsel appearing for the petitioner, also heard Mr. S.K. Talukdar, Learned Counsel appearing for the respondents. This writ petition had been instituted challenging an order dated 25/3/2022 passed by the,
Junel Joint Registrar,
passed by
Junel Joint Registrar.
Zonal Joint Registrar of the Cooperative Societies, Silchar.
Zone.
And further praying for a writ in the nature of mandamus to allow the petitioners to manage the affairs of the above society on being elected as chairman and board of directors of the Bikrampur Cooperative Society Limited, Behera Bazar. Full stop. By an interim order dated. Where is that interim order?
1/4/22.
1/4/22, my lord.
An interim order dated 1/4/2022. This court had required the parties to maintain status quo with regard to the order dated 25/3/2022 relating to the appointment of a one-man committee, full stop. It is the case of the petitioners in the writ petition that they were elected to the board of directors
On
an election held on 10/6
para 2, my lord.
10/6/2018 and 2000 full stop. When the zonal registrar,
Joint register.
when the zonal joint registrar of cooperative societies tried to intervene in the functioning of the board of directors by appointing a one-man committee, the petitioners had approached this court, full stop. Today, when the matter is taken up, Mr. S.K. Talukdar, Learned Standing Council Cooperative Societies has made a submission that the period of the board of directors, of which the board of directors can hold office after election is 5 years, and therefore the elected members in the year 2018 have already spent their tenure in the year 2023, and thus nothing remains for adjudication in the present writ petition relating to the prayers made therein, full stop. Mr. B. Sinha, Learned Counsel for the petitioner, has submitted that there are arguments which can be made in the writ petition and which may require an adjudication, but he submits that it remains a fact that the board of directors had to demit office in the year 2023 in accordance with the provisions of the relevant act. Full stop. In view of the fact that the board of directors have completed their tenure in the year 2023, and now a fresh body is required to be elected in accordance with the act and the rules applicable, this court does not find it prudent to keep this writ petition pending in its present form, full stop. In its present form, full stop. Accordingly, this writ petition is closed and any interim orders passed earlier shall merge with this final order, full stop. Final order, since now the action of the zonal joint director would have
Joint
no-
register.
a zonal joint registrar would have no further value
Hearing.
once the board of directors, once the term of the board of director has expired, full stop. With the closure of this writ petition, the respondent authorities will now take appropriate steps to ensure that appropriate elections in the cooperative society is conducted to ensure proper functioning of the cooperative society, full stop. Writ petition stands disposed of, no costs. Petitioners, if you have any grievances,
An outer limit, my lord, may be given. Outer
I
limit,
said according to law, there must be some limit.
limit has already expired because
Now
there is
automatically
a limit, my lord.
one-man committee will come.
Just go by that.
My lord. Under 41(6), if your lordship meant.
Just go by that.
Yes.
If you
The
delay
automatic-
proceedings, they will not come back to the court. If your people sleep on it,
Yes.
they will come back.
They will come.
Yes, Abdul Ali. Yes.
Budget has been released in favor of DTU.
Payment may be made.
Maybe made within short time.
Yes,
W. Rahman.
2 lakhs
Yes, my lord.
has been released. Budget has been released, you will get it in your account possibly.
Yes, my lord.
What to do, close it?
My lord, within a specific period, my lord, may be dispersed, my lord.
Okay. You are Mr.
W. Rahman.
Huh?
W. Rahman.
Have you heard the word
Free left.
saved by the skin of the teeth? On the last occasion, we were about to dismiss it. Yes, heard Mr. Swenson, Learned Counsel appearing for the petitioner, also heard Mr. A. Bhattacharjee, Learned Standing Counsel appearing for the deputy commissioner,
No.
For the
Number one.
respondent number 1. Miss M. Burman appearing for respondent number so and so, so and so. Full stop. Mr. Bhattacharjee, learned counsel has placed before this court an instruction received by him on 3/11/2025 to the effect that the Revenue and Disaster Management Department has released a budget allotment for an amount of rupees 2 lakhs to the DDO concerned for making payment of ex gratia grant to the next of kin of late China Khatun. Full stop. The prayer in the writ petition was for a direction to the respondent authorities to pay the ex gratia amount of rupees 2 lakhs to the petitioner against the untimely death of
Wife of the petitioner.
of his wife. Full stop. Since the respondent departments has released the budget allotment for the amount, and it is expected that in a short time, the payment would be made to the petitioner after completion of formalities.
Yes.
Comma. Nothing remains to adjudicate in the presented petition, and therefore it is closed. It is made clear that if the payment is not made to the petitioner within a reasonable period, is not received by the petitioner within a reasonable period of time, upon his completing his part of the formalities, comma, he would be at liberty to approach this court again.
Preferably within, my lord.
Huh?
Preferably within, my lord.
No, we have said that if you don't receive it in a reasonable period of time after you do your part, now you have to identify yourself, get your
Yes,
papers and all.
Yes, ma'am.
You do that, you don't get the money, come back.
Yes, ma'am. Okay.
Yes,
This matter is relating to payment of ex gratia relief. As per the information of the petitioner, he has got in
anything, madam, any updates?
Lordship, this matter, Your Lordship, the vehicle has been identified. Also, as per the order dated 21/6.
If the vehicle is identified,
Yes, Your Lordship, order dated 21/6,
you have to go
2024.
for an MSCT claim.
already
Done.
done.
So this petition does not survive.
As per the instruction of the petitioner, sanction has been already sent,
To whom?
prepared by the decision sent to the government.
But then Your
Some
Lordship,
official of the
there is
DC office,
a decision
told-
of the Honorable High Court. Your
some officials of the DC office told the petitioner that your sanction has been sent.
No, it has been sent for sanction.
No, sir, sent for budget allocation. Sanction is prepared and sent by the deputy commissioner to the revenue department, then release from the dispute.
The Revenue Department, the work has not proceeded because of this order, Your Lordship.
So instructions update hotta there.
For a sign, Honorable. I've already emailed the order, Your Lordship.
Which order? This High Court order?
Yes, Your Lordship, passed in WPC 27.
He is in expectation that if the sanction has been sent, maybe the money will come if the writ petition is not disposed, perhaps that is his expectation. Unless you have a written instruction saying that, but this is a point of law. I can't wait for instructions on this. Huh?
They have comes before.
Huh?
14 points order comes before 21/6. So probably he's made up. Yes, Your Lordship.
Oh. This is an order of 21/6/2024 and the death is of,
Yes.
it will be rejected.
Yes, Your. Wrongfully.
Lordship, some people are getting compensation as per the
Wrongfully
earlier notification. Even at present, some people are getting.
Concept in law saying negative equality.
Yes,
Maybe
if you-
this order is
the-
not
an
circulated.
affidavit,
Your Lordship.
a direction may be.
Don't say yes, I'm saying against you. Negative equality goes
Yes.
against you.
Yes, Lordship, and
Maybe
if
this order is not
if
circulated
appeal
amongst
is-
the districts.
appeal
Your
is
Lordship.
pending,
That's why we-
the next day, the 6/1
What appeal?
against division bench appeal is pending.
Against this order?
Yes, not my
This-
case, not my case, another case.
No, what?
Not in this case. Your Lordship, this case, which
Ah.
forwarded.
But there is no stay.
There is no interim order, no stay. The matter is always
Final-
being adjourned by the,
Appellants.
yes, Your.
But at the time of hearing, I observed that there are much hope in favor of us. Lordship, that till a date may be fixed after 6th day of January.
Huh?
It may be granted to them if that delayed judgment is in their favor.
We can do two things. that,
After 6th day of
we
January,
can say that this covers it. As of now, this covers it. And
Yes,
any orders passed in the appeal will also govern the case of
Yes.
the petitioner.
Yes, that can be done.
Lordship, actually, against this order, I have to tell something. If your Lordship is ready to hear my
Please.
Lordship. At first, the notification,
Yes, Ms. Bodley, take your seat.
Yes.
but the impound judgment is relied upon the notification passed on 31st/10/2023. But my accident is prior to effect of that notification. Here is written, this notification will came into force from 1/11/2023. Kindly peruse. Number 5.
In the case before the coordinate bench, even before the coordinate bench, this Monisha Khatun or what?
Yes, right.
Monisha Khatun.
Yes.
Monisha Khatun case was also prior to this 23 notification.
Lordship,
23 notification has been referred to only at the end of the judgment.
yes, Lordship.
Prior to that, the situation prior to that has been considered by the coordinate bench.
Yes.
Am I not bound by that?
Relying upon the decision of Shashi Sharma judgment.
Ah.
This judgment was passed, relying upon a judgment passed by the Honorable Supreme Court.
No, not
Reliance-
relying on it referred to. The entire reliance was not there.
There
It
Here is
just drew some more power.
that ex gratia is separate, this ex gratia is separate.
Huh.
In this notification, it is written that government employees are not within the purview of this notification. In this notification, here is a line written.
Which notification? 23 notification.
Yes, Lordship.
We are not discussing the 23 notification at all. We are trying to see that under the earlier notification, whether you have a right or not.
Yes, Lordship.
Now this coordinate bench says that you don't have a right. The judgment by the coordinate bench, in the judgment, the coordinate bench says, Shashi Sharma also says so.
Discuss.
Recent OM also says so. But the recent OM is not depended upon to deny that.
Lordship,
Right.
I have to tell something. Kindly reflect.
We are trying to
Yeah, Lord.
yes.
Section 167 of Motor Vehicles Act, there is a provision.
But for provisions of
167.
section 1,
167.
section of motor vehicles act, should the read code be?
Yes, Lord.
Motor vehicles act. In fact, if even if you are not a party in Monisha Khatun, but you are aggrieved by the judgment because
Yes,
it will
sir.
affect your right, do you not have something to go before the division bench? I think there is some provision where you can say that I am an affected party. Yes.
167.
Mm.
Option regarding claims for compensation in certain cases, notwithstanding anything contained in the Workmen Compensation Act
এখন motor vehicle rule কোন
1923,
দিকে?
where the death of or bodily
Read slowly.
a person have two options. If my claim is maintainable under Motor Vehicles Act and Workmen Compensation Act, simultaneously, I cannot choose both options. Only I have one option. But in the notification, nowhere mentioned where I am entitled MACT claim, this notification will not cover. But in the Motor Vehicles Act, here is nowhere mentioned that my ex gratia is not maintained. This is clear. As per section, but these are not discussed, Lordship. Actually, I am telling this, these are not discussed. Moreover,
So the best I can do is with all these discussions, I'll again refer it to the division bench.
Lordship,
If I change my mind, if I do not agree to that judgment, I
Yes,
will
Lord.
only have to refer it. It is already there. Why don't you
my matter
participate
may be
there?
referred with that matter.
No, we'll close it in accordance with this judgment and only then you can go and make an appeal saying that no, I will not be there. This is wrong. Hear me also. Then only you can say if I close your writ petition, then only you can go there. Otherwise, how you can go there?
So, Lordship, if they mentioned this, motor
Claimant?
vehicle, they've already received the claim, Your Lordship.
I think we go with driver license. Huh?
Already received the claim under the motor vehicles.
You received that claim also.
Yes, Lordship.
Ah,
I admit.
how is he?
Try your luck.
But this, my submissions
Try your luck there. I think that will be better. You are Mr.
are Deka.
Ardeka. And the council is paying for the petitioner. Also heard Miss N. Baudelaire, and the council appearing for the respondent number, M. Bormon, appearing for. One already. Madam Bormon, you are appearing for 3 to
3 to 5.
3 to 5, and Miss N. Baudelaire
For one.
actually paying for
One.
respondent number 1. On the last occasion, it was submitted that the issues raised in this writ petition are covered by the judgment and order dated
Order dated 21/6/2020. 21/6/2020.
21/6/2024 passed in WPC number 27002023 full stop. We have gone through the contents of the writ petition and the order referred to full stop. We have the view that the issue raised in this writ petition is covered by the judgment and order dated 21/6/2024. Accordingly, this writ petition is closed. On the same terms on which the WPC number 27002023 had been decided. Full stop. It is made, the learned counsel for the petitioner has submitted that the judgment and order passed in WPC number 27002023 has been taken up before the before the division bench of this court in appeal. Stop. It is made clear that any orders passed in the appeal would also govern the case of the petitioner herein. The petition accordingly disposed of.
Liberty,
Huh?
liberty may be given if appeal will in favor of the petition.
That is what I have said, that any orders passed in the appeal will govern your case also. Or should I not say that you want to go in and appeal directly?
Yes.
Obliged.
May I please, Your Worship?
Yes.
Item number 12 also similar, same order maybe.
Record his presence. Item number 12. Itu kiman dito? 10. You come up when item number 12 is called.
Lordship,
Convenient for us. Yes,
It is for better.
yes, sir.
My lord, this is with regard to providing personal security to the petitioner.
Hmm.
Petitioner, he is a social activist of Poskwa Sapuri village of Tejpur.
Hmm.
He was also a secretary as well as president of village defense.
Hmm.
While working as president of the village defense, he worked with close contact with the police authorities, and he helped gave various information
Hmm.
regarding drug peddlers to the police authorities. In that way, in one incident, he was so brutally attacked by
Page
drug
39.
mafia. Yes, my lord.
Yes,
If you
we've
could
seen
see
it.
the photographs, he was sliced like anything, his entire body, my lord. So in that view of the matter, the petitioner submitted a representation praying for police protection.
Yes.
And they set over the matter. And finally, they have filed an affidavit saying that para 8 of the affidavit, there is no threat perception.
Okay.
Now, if you also kindly take page 44,
Hmm.
para
What
8,
happened to the persons who sliced you? Were those persons?
cross FIRs were filed.
Huh?
First my FIR, then
Ah.
they also filed FIR.
Ah.
There is a misstatement in the affidavit that I'll clarify, my lord, that I was arrested.
You were not arrested. Okay, we
Yes.
go by your statement.
That trial is going on. So
The
far.
trial is going on.
Yes,
And
my lord.
after that, there has been no attack.
Thereafter, my lord, one incident I have again lodged an FIR, which I have annexed in
Now,
my affidavit in
Mr.
reply.
Das, can we sit here to say that whether there is a threat perception or not?
No, no.
Two, there was an interim order for them to consider, they have considered and rejected. Now, a security threat to yourself, perhaps there are other avenues where you can take PSOs from private security agencies also, not a person from the government. Because a government person, once someone is detailed to you, some space goes blank in the battalion. That requires to be filled up. This man is constantly, and a private person's having government people serving them, whatever be the cost, that is otherwise, but someone who's not serving the government as of date.
My lord, may I just,
Unless the security threat is felt by the government, can we pass an order saying that you should do this?
my lord, may I just place one fact aspect before you,
please,
lord?
please.
Para 8, your lordship will kindly have.
Of?
Para 8, page 44.
Huh.
Para 8 of the affidavit.
Yes.
It says, with regard to a statement made in para 8 so and so, a representation with regard to requirement of PSO dated so and so was submitted by the petitioner addressing to the AGGP SP Assam and the Superintendent of Police Sonishpur Assam. And accordingly, as per the procedure, a threat assessment report was received through the range DIGP NR Tejpur.
Mm.
As per the threat assessment report, there is no specific threat and accordingly PSO was not recommended.
Mm.
Further, as per the threat assessment report, a case was registered against the petitioner at so and so. The petitioner was arrested and the case was charged sheeted by so and so.
Mm.
This was absolutely wrong.
We expunge this. They
Number
will give
one.
their
So
apologies, we
they say,
expunge this.
as per the threat assessment report, some criminal case was registered, but fact remains that they have done some kind of threat assessment in the representation of the petitioner. Now, my reply, if your lordship kindly have, because in the affidavit in reply, I have annexed one OM issued by the government of Assam. This is OM dated.
So we can do another thing. We can say, we can take note of your reply. We can set aside their disposal order, the order by which your representation was disposed.
No
because-
order was passed.
No,
This reason came in-
no
yes.
threat. We say that they have, according to you, they have taken this Tejpur PS into consideration while saying that there is no threat to you. That appears to be wrong. They will do a fresh consideration.
That can be.
That is the best.
Fine, my, that can be. And the lordship may
Your
refer.
reference to the Tejpur police case, where you say that you had been arrested, he had been arrested. It's a false statement on affidavit.
He has been arrested in.
Do you have the arrest memo here?
No, madam. That's PS 309.
Uh-huh. See, he says that he was never arrested in 793.
There are two cases.
Yes. PS case number 309-2023 and 793 of 2023.
Yes.
In which was he arrested? 793?
309.
Huh?
309. And search sheet was.
No. Your statement says petitioner was arrested and the case was charge sheeted by charge sheet 793. So 309 is the only case. There are no two cases.
Already been searched.
313, he made an FIR
Yes.
that was charge sheeted. He cannot be arrested in his own FIR,
My lord, my.
perhaps.
My lord.
Then you have another case, 309.
309.
Now this 309, you are saying that it has become a charge sheet in 793 of 2023 and he was arrested. He says he was never arrested.
My lord.
So if he was never arrested, if that is correct, then your assessment, that threat assessment on the basis that he is the person being arrested, what is the threat to him? That should be the conclusion. If that is wrong, you need to reconsider.
My lord, fact remains that he was searched under
You-
section
you-
302.
If, huh?
Under section 302.
That is a cross case arising from the other one. That is what he said. It's a cross case of 313. 309 was against you. 309 and you filed the case 313.
313.
So yours was later.
Yes. it
You were
can-
the cross case.
Yes.
Yes.
I was the
So
victim.
now they say that 309 you were arrested. You say you were not arrested.
I have, my lord, annexed the bail order.
He was never arrested.
I was never arrested.
He was under bail.
Right.
So if he was never arrested, would you be required to relook the order, which relook the conclusion that he does not need a security? You have to just relook it. That he was on bail.
Probably, Lordship, we have to place the threat assessment report. So Lordship may give some time, Lordship will place the threat assessment report.
Whether
Not only that, other count will be also there. Lordship.
something,
Something is there, Lordship. That's why Lordship.
something, even Mr. Gogoi,
Lordship, Lordship.
just,
Something.
just a little out of the way. If he is a threat, then also you should give him a PSO so that he cannot be a
Then
threat. to
Lordship,
anybody.
everybody come, Lordship.
No, no.
Tomorrow.
Please
it
listen.
might- Everybody.
I am
come.
saying he does not have a threat.
Lordship.
He may himself be a threat to someone. Even then you should give him a PSO so he
Then
cannot
Lordship-
threaten
then
anybody.
Lordship, no persons will be there, not a single PSO Lordship.
This
Everybody.
is a very
everybody
generic
needs a-
statement by my
every-
learned brother.
Everybody needs PSO Lordship.
Okay, you want to
Everybody
bring the
doesn't
threat
need
assessment,
Everybody needs PSO Lordship.
threat assessment on record.
Lordship, we will place it, Lordship.
Okay.
Yes,
Heard Mr. H.K. Das, Learned Counsel appearing for the petitioner. This petition has been filed, being aggrieved by the fact that the request of the petitioner to be allotted a personal security officer, if required at his own expense, had not been considered by the respondent authorities. Full stop. An affidavit has been filed by the respondent authorities stating that as per the threat assessment report, there is no present threat to the writ petitioner. Full stop. Mr. K. Gogoi, learned additional senior government advocate appearing for the respondents, has sought for some time to place before this court the threat assessment report.
Lordship.
Full stop. Allowing him 3 weeks' time, list this matter again in the week commencing from 15th of December 2025
Lordship.
to produce the threat assessment report on the basis of which further adjudication in the matter would follow. But otherwise, I think
I understand.
going for a private
Yes, I understand.
appeal যাব পাৰে বুলি।
My lord, may I pray for a date, my lord, fixed date? If
No, we said 15th of 15th,
will
week
come.
commencing 15th, that is the last week before the
Vacation.
vacations, so it will just come up. Let
Fine.
them adjust it.
Fine, ma'am. Highly appreciated.
Yes, Mr. Bora.
My lord, so far the criminal revision petition that is withdrawn, my lord,
Ah,
and that was only contented by the respondent.
ah,
That because of that pendency of that, they were not able to dispose of my representation so far that was filed for the demarcation of my land.
ah.
So at that, and last time I prayed for before this honorable court, my lord, seeking time to withdraw the matter, and that has been withdrawn.
So the criminal revision now gone?
Yes, my lord.
It is closed?
Yes,
That is
my
the
lord.
only
Proceed,
reason
may
why there
close
is-
it
yes,
by
Ms. Bodole.
directing the authority.
Since now he has withdrawn the criminal revision and there is no status quo order or any other order operating anywhere. Although that criminal revision, perhaps if you remember correctly, was filed after the original order has lost all import. He had filed the revision then. Now the revision is also gone.
Yes.
Now can you take up the steps for demarcation?
Yes, sir.
Hmm?
For the deputy commissioner, lordship, the demarcation is done by the.
Mr. Sharma, you
Sir,
will be appearing for the deputy commissioner,
It would be like it.
Item 11.
item 11.
Yes, sir, lordship.
We'll tell you what has happened.
Lordship.
He has some problem with the demarcation, he made an application. Someone filed another application, the magistrate passes an order of restraining him. After that, 3 months of that order, when that order has lost all force, he comes before this court and files a criminal revision against that order. Court orders a status quo. He files a writ petition saying my demarcation is not done. Now he has withdrawn that criminal revision petition because it is of no use. So now there is no court order stopping you from
Yes.
demarcating the land. Can we pass an order saying that since now there
Yes,
is no
yes.
other litigation, his representation for demarcation will be taken up by the authorities and disposed of within a period of 60 days from the date of receipt of a certified copy of the order?
Yes.
Yes,
sir.
heard
That can
Mr.
be done.
D. Bora, Learned Counsel appearing for the petitioner, also heard Mr. H. Sharma, Learned Counsel appearing for all the respondents? For respondent number 2 to so and so?
2, 3 and 4.
2, 3 and 4, Miss
My
N.
direct-
Bordoloi, Learned Counsel appearing for the respondent number 1, full stop. On the last occasion when the case was listed, the learned counsel for the petitioner had sought for some time to have instructions and or to have the criminal revision petition number so and so 340 of 2023 closed so that further orders in this writ petition could follow. Full stop. Today he has informed the court that the criminal revision petition 340 of 2023 has been withdrawn by the petitioner, and therefore now there is no legal impediment in the way of the respondents to consider and dispose of the representation filed by the petitioner seeking demarcation of his land, of the land in issue, his land in issue, full stop. Mr. Sharma and Ms. Bordoloi, learned counsel appearing for the respondents, have submitted that now since the impediment has been removed, the respondent authorities would consider and pass appropriate orders on the application of the petitioner seeking demarcation, full stop. In view of the above, this writ petition is disposed of, directing the petitioner to file a fresh representation to the respondent authorities along with a copy of this writ petition and a certified copy of this order. To the whom?
Fresh application.
Fresh
Yes,
application.
yes.
To whom? Tell us, sir.
Circle
Tell us, sir.
officer Soigaon.
To the circle officer Choigaon, Kamrup Rural. Huh?
Yes.
Within a period of 15 days from
Yes.
today, and on receipt of such an application, the concerned authority, namely the respondent number 4, circle officer Choigaon, shall inform the petitioner if any other formalities are required to be fulfilled within a period of 7 days from receipt of the application, and upon the petitioner completing formalities, if any, the representation required by the petitioner shall be disposed of within a period of 60 days from the date of receipt of the representation as aforesaid, full stop. Writ petition disposed of, no costs.
Also placed.
May I please, your lordship?
Yes, this is covered. This
Lordship,
will be
in
like-
this case, your lordship, I would like to supply a judgment passed by the Honorable Justice Ujjwal Bhuya, your lordship. In this order, your lordship, clearly mentioned, petitioner has been entitled both the claim, MACT,
এইটো কেতিয়া order হয়?
Gunolok.
এইটো 15
পিছতটো আহিলে এইটো, পৰীক্ষা।
24 judgment has come now.
Lordship, as per this judgment, several number of petition has been disposed of by this honorable court, and those victim people are already get the benefit.
Where is it said that both they
Yes,
entitled to both?
Lordship, page 3,
Yes.
before the last paragraph, your lordship. Lordship got it? Here clearly mentioned, your lordship, in line number 3, your lordship. In addition, may I read?
Yes, yes, please.
Yes, lordship. Therefore, the ex gratia payment would be mean a payment made by the authority beyond the legal requirement or consideration. It is a payment which is unconnected with and unrelated to
What is the
the
other judgment, the earlier judgment, the recent judgment, equity auction? File to provide item number 10,
Item
10, 9.
item 9, it was there in item 9.
And interestingly, part is, your lordship, item number 6 also same. But that case already sanction has been forwarded to the revenue department.
Huh?
Item number 6 also same. Same issue, same nature.
Structure was available with the standing counsel, your lordship. In
What is
item
going
9,
on, your lordship?
In item 9, your lordship,
Same
instruction has
nature.
not been received.
Some
your
person
lordship,
getting
from
and some
the
person
department.
not.
That is the difference between the two items.
I can't have two of you speaking together. There the 2 lakhs compensation has
Yes.
been sent.
The revenue department. In the
See,
next.
if
item-
they're paying it
So instruction-
beyond the orders of this court, there is a situation where they decide to pay.
Lordship.
And there is a situation where you come to this court to say that, ask them to pay.
Yes.
Now, we are required to pass orders which will be in accordance with law. We cannot go beyond the law. They can make payment to anybody.
Absolutely.
We cannot stop them.
But
But if you say that that is loss of public money, this and that, of course you have the appropriate forum to do that. But we will not be taking into consideration that they paid someone beyond the orders of the court because we cannot go for negative equality.
Lordship
There is a
has-
concept called negative equality.
Absolutely.
Something wrongly given,
Ah.
we cannot ask them, okay, do it for him also. Cannot do
Exactly,
that.
That was correct, but
Our hands are tied, tied.
that was correct, Your Lordship. But as per this judgment,
Here was this judgment taken into account, Gunalata Das?
do not-
No, Your
here, Lordship, Honorable Justice Ujjwal Bhai clearly
Ah,
said
it has been taken into, it
It
has
is-
been taken,
Yes, yes,
it has been taken into
But-
account.
yes. And it was
that part has been not mentioned in Manisha case, Your Lordship.
That you can,
That will be favor, that will be better, I mean, if Your Lordship mentioned in our order, Your Lordship, that part in appeal, Your Lordship. And in this order, Honorable Justice has clearly said that this is a beneficial legislation. Therefore, District Legal Service Authority has arranged the program, awareness program, and award the civil people regarding
You
this
please,
notification.
you please go into this. Do you have this order? 2700 of 2023. The recent order, do you have the recent order?
Yes, Lordship.
Take it up. Para 18.
Page 14.
Para 18. Do you see?
Page
It has been
14.
mentioned. Yes.
The court is aware of its limitation when it's related to the residential bail of the judgment coordinations. However, it is then when the case so and so. In this order,
There is
Honorable
a,
gives
there is a
more
coffin.
presidential.
There is a coffin.
Yeah.
It is closed and there is a nail and you are putting the last nail in the coffin. Okay.
when item number
Yes,
was taken up, he was mentioning for similar order. Now he's coming up with it.
And same order as item number 9. The same order will do. Will make
Lordship,
necessary correction. हाँ इसमें आप
Up
लिखिए
to you, Your Lordship.
पास में लिखिए the learned counsel for the petitioner has submitted that the orders passed in WPC number 2700/2023 did not discuss the judgment and order dated 4/5/2019 passed in Gunalata Das and others versus State of some others within bracket reported in 2019 within bracket 4 GLT 17 full stop. We have seen the judgment of the judgment passed in Monisha Khatun, Supra has taken into consideration the decision of this court in Gunalata Das and others Supra. Full stop. Okay. I'll add a 1 or 2 lines on that.
I'm so deeply obliged.
Pleasure.
Yes.
Malad, in this case, the petitioner for Lordship Malad, he obtained an NOC for
Let's check. The earlier judgment that relates to only in case of residential flat and all that. Not in case of land, transfer of land. Because in 2009, the registration Assam Amendment Act 2009 came into operation, which stipulates that no testamentary document will be registered without the NOC from the Deputy Commissioner.
Here, he was given an NOC that was that he could not execute the sale in time. Then it was
Then it was
extended.
extended.
Then it was extended twice or once.
once.
once. That time period also lapsed.
Left.
He did not get it.
Within
He
that-
could not again execute it. Therefore, now he is before this court to say that please extend it again. And your stand is no, you apply afresh. It's a difficulty.
my lord, my case is that, my lord, after obtaining the NOC, I applied for, my lord, I prepared a draft. Possibly kindly turn to page 23.
Hmm.
This is the, my lord, sell deed.
Hmm.
But I could not register it, my lord, due to financial constraint.
Huh?
Due to financial constraint, my lord, I could not register it.
Good.
And therefore, my lord, I prayed for an extension at page 29.
Granted.
Within the validity of the extended period, my lord.
Granted.
My lord, now.
That was
my lord,
granted.
my lord, that was not granted.
No, first time it was granted.
First
no.
time it was granted.
Then?
My lord, during the, my lord, validity of the extension period, my lord, I prepared the draft. I prepared the
See,
tell
what we understand is if an NOC has been given to you, it is given to you under conditions that prevails on the date that the NOC has been granted.
Right.
Since the conditions continue to prevail the same,
Right.
an extension was also granted to you.
Yes, ma'am.
Now, whether the conditions remain the same or
My
not,
lord, the
whether it,
value-
whether the
land
extension
value
can
has
be
not been
granted or not.
changed.
Huh?
Land value of that area, my lord, has
Ah.
not been changed till today,
I
my
do
lord.
not know if it had, if everything was okay, they would have extended it.
My lord,
There must be something wrong for which they are saying we will not extend it. What is that wrong?
I don't know, my lord, what is the
Why
wrong?
not extend it? What is the difficulty? Any affidavit filed?
Just,
No, my lord, they have not filed any affidavit.
Huh?
They have not filed any affidavit.
no, Lordship, I think the anxiety of my learned friend regarding this e-stamp.
And
That's
the
because
pen-
he has bought this e-stamp at 2 lakhs.
And he did not use it
2,000.
in time.
But it is not used. So he can use it again by making a fresh application. He can use it. I had a talk with the sub-register today till morning. That this person is suffering. So
Then what
can
about
be
the
done?
NOC? What about the NOC?
That NOC he can apply for fresh
Apply
by
fresh,
making
get it.
by making an amount of rupees 2,500 or 3,000.
And whom are you selling it to? Then you have a new land, a new this thing, no?
E-stamp
My
Lordship,
lord-
this is not
Ah,
in use. So accordingly, he can use it again.
Rama Taraftar, Niranjan, everything will remain. Why
Yes,
don't you
Lordship,
apply
that
for
much
one?
My
Lordship.
lord,
Otherwise,
I made an alternative submission in this
To?
case because, my lord, there is a construction over the
Ah.
plot of land.
Huh?
There's against construction, my lord,
Ah.
against which, my lord,
So you don't need an NOC?
Yes.
That question of law, if you start deciding now, you will wait for another 2 years.
That has been decided by Central Court, my lord. That
Not all
requirement of NOC.
structures.
Yes, my lord, it is said,
this is regarding
If it
land
is a
and
part
its
of a
judgment
flat,
which my
then the law says.
not only flat, my lord.
Please.
May the other day I gave the judgment, my lord. May I read the relevant paragraph, my lord. Paragraph 23.
Then you have to read it because it is not here.
I think
Well,
Lordship,
paragraph 23,
it will be
I- I'm-
detrimental to
I'll
the
say-
interest of the petitioner Lordship. It is the easiest way Lordship. That is why I asked
Paragraph
the-
23.
I had a talk with the sub-register today itself morning. What can be done with this person? These are old persons. I want to help them. So they have sent
Law
me
is a 3-alphabet word.
Lordship.
So is ego. Yes.
Paragraph 23, my lord.
That house, flat, residential apartment, commercial building. Outside the purview. Yes. So you buy the house, don't buy the land.
Lord, if-
Buy the house with the proportionate share of the land. You don't need an NOC.
Yes, my lord.
If you want the land also which is attached to it, surroundings, NOC. We'll determine it that way. That is why I think it's been determined. If you want to buy the house without the land, no NOC. I was advised in accordance with that. That if it is a land, if it is a house with proportionate share of land, no NOC.
My lord, the-
But
about
if
the
it is a
land-
house with 100 bighas of land in its boundary, can we say without an NOC? Yes, yes, read it.
my lord, the act says,
Ah,
except for house, flat, residential, apartment, commercial building, or any construction as erected on a plot of land.
That is what I'm saying. The house, the flat, the residential apartment, the commercial building, and any construction
Right.
is outside the purview. What about the land which is attached, not proportionate share, the land which lies in its entire surroundings in the campus when you buy that part of the land, where you can make more constructions, that land is not exempted. Otherwise, any plot of land, any structure has to stand on a plot of land. However big or small it has to be on a plot of land.
May I?
Only vacant land will be with an NOC if we go by your argument. Can that be? No. So what to do? You want to apply for a new NOC, bring an end to the ordeal? Or you want us to say that we cannot decide the respondents' intelligence or wisdom in wanting to extend or not to extend? We cannot substitute our views.
As after completing all the formalities, they have issued an NOC in favor of me.
They extended it for you.
They can even extend it also, my lord, as there is in the other registration act,
They-
my lord, there is no provision of, my lord, time
The
limit.
question is not whether they can, the question is whether we can force them to.
They can reconsider.
Can we
my
give
application.
can we give a mandamus to say that you do it?
They can reconsider my application, my lord. I have
Why not? Why?
page 29, my lord, I
What
have
is the
applied.
difficulty in applying? We just want to know.
Well, it will start from zero, my lord, again, my lord. If I
Lordship,
wait
the
for a-
other lordship, GMDA permission he has, there is no such time limit.
There is no extension on that. So GMD.
So
but
that is
GMDA
there.
there.
The
He's
East
making
Stamp is also
submission,
there.
he's making statements in the court, so don't
Fine.
worry. This will be to your favor. Yes.
Yes.
And only the NOC where that 60 days time limit is there.
Ah.
Let him obtain the NOC. Other parts already he has.
And you perhaps the respondents looking at the peculiarity of the case can do it within a certain time frame
Can be lordship.
because of the peculiarity of the case. Yes.
In the GMC permission, even we have, my lord, given 1% of the total value, my lord, deposited 1%
Ah.
of the total value.
Ah.
In the GMC permission.
Ah.
If the value has already exceeded lordship, in
What-
that
what-
case he has to make the extra.
The
amount,
thing is, if
extra
you have
payment.
if you already have a GMDA permission to sell it,
Yes,
it is not barred by time.
it is not bad by time. It is not bad by time. And I have also deposited the, my lord, required fees, that 1% of.
I have seen the NOCs submitted, NOCs given by the GMDA. There is no such provision. Only that DC
So is
the permission from the NOC.
Which of the three letter alphabets do I go with? Which word?
Lordship, may ask the deputy commissioner to, my lord, grant the NOC, my lord, within a time frame.
You make an application with all these facts. You make an application with the peculiarity of the facts. The respondents will consider it within.
Lordship, there the provision is already there in the, it is to be given within a period of 30 days.
Accepted
If
or
it exceeds, he has to give a
Make an
30 days limit is there already.
I think you should make an application. What do you say? This will not prejudice you because he has clarified all, dispelled all,
Yes, Lordship,
all
that's
doubts.
because I have.
The stamp papers are not going waste.
Right.
The GMDA, no objection is not time limited.
My lord, regarding the stamp paper, Lordship may observe, take some of them.
That's because this time, I have been
We'll
told that
say-
if this stamp, e-stamp is not in use, but
Hmm.
from the document he has annexed, the
Hmm.
e-stamp,
It has not been.
I have seen that it is not in use.
Others, how can you lose validity if you don't, if you have not got it registered somewhere, if you have
I
not
have
used
not
it
got
for the purpose,
No, my
for
lord.
any purpose, it cannot lose validity.
Page 23, Lordship,
Ah.
there is no any stamp here, Lord. So it is not in use. You can use it. If it is in use, Lordship, in that case, he can. But from the annexure, he has annexed at page 23.
Use,
Yes.
you know, e-stamp, my lord, I cannot use also.
Hmm?
And use e-stamp, I cannot use, reuse it. my-
If he had made that application and then something bad would have happened, he was hospitalized, could
Because
not
Lordship,
sign,
this
another con-
situation occurred at the
then other
time of.
considerations, but it was on his valuation that time and again you could not use the extension part. Yes, heard Mr. I. Sekar, Learned Counsel appearing for the petitioner, also heard Mr. H. Sharma, Learned Counsel
Well-
appearing for the respondent number 2 and 3, and Mr. A. Bhattacharjee, Learned Counsel appearing for the respondent number 1. Full stop. This petition had been filed by the petitioner, praying that the permission for the NOC for sale obtained by him from the respondent number
2, my lord.
2 on what date?
On 8/1/2021.
8/1/2021 may be directed to be extended for a further period so that the petitioner may have the opportunity to have the sale deed executed, full stop. It is the case of the petitioner that having obtained the NOC dated 8/2/2021, he had taken up the
8/1.
8/1/2021, he had taken up further steps for having the sale executed by him or in his favor. He wants to buy or sell.
In his favor.
He wants to buy it.
Buy it.
Sale executed in his favor by the intending seller.
Right.
However, due to certain difficulties, he could not have the sale deed executed and registered within the time frame given in the NOC dated 8/1/2021. On his application being made to the concerned authority, an extension was granted to him till
Page 22, Lordship.
till
For a period of 3 months
for a further period of 3 months
on 25/5/2022 till 23/8/2022.
Huh? It was given an extension till 23/8/2022. Full stop. The learned counsel for the petitioner submits that the sale deed could not be executed during that period also because the petitioner was suffering
Correct.
from certain difficulties regarding his financial capability. Huh?
This sale deed was prepared on 5th of August 2022, my lord. It could not be
Full
registered.
stop. He has drawn our attention to the fact that the sale deed was in fact prepared on the 18th day of August 2022. Page 24 top line.
My lord, 5th of August, my lord.
No, page 24 top line, 18th day of August 2022.
My lord.
Sale deed was prepared on 18th of August 2024 with the e-stamps having been bought on 5th of August 2022. Full stop. He therefore prays that if the permission for sale is extended, he may have, he will have the sale deed executed within the extension granted. Full stop. Mr. Sharma and Mr. Bhattacharjee, learned counsel, appearing for the respondents, have submitted that once an extension was already granted, but the petitioner could not avail the benefit of reasons for reasons best known to him. And it cannot be his case that on his every application an extension can be granted because there may be some circumstantial changes in the meantime, which may require reconsideration. Full stop. Faced with this situation, on a query made by this court, Mr. I.H. Saikia, learned counsel, appearing for the petitioner, has submitted that the petitioner would not be averse to applying afresh for grant of an NOC for sale to the concerned authorities, and the only apprehension is that the stamp papers which have been already brought and the GMDA permission which was taken in the year 2022 may suffer may cause to be a hindrance in the grant of a fresh NOC. Full stop. Mr. Sharma and Mr. Bhattacharjee, learned counsel, appearing for the respondents, have dispelled such doubt, saying that an unused stamp paper can be used for carrying out the sale transaction if the NOC is granted and the permission of the GMDA remains without a period of validity, meaning thereby that the sale can be carried out even at a later point of time. Stop. Having heard the learned counsel for the parties, this writ petition is disposed of, permitting the petitioner to file a fresh application for NOC for sale of the land in issue in this writ petition. And upon receipt of such an application, the respondents would take appropriate action in accordance with the law regarding issuance of such NOC. Full stop. It is made clear that the earlier NOC, the validity of the earlier NOC having been granted to the petitioner having expired will not in any way influence the respondents in consideration of the fresh NOC to be granted to the petitioner. Full stop. Yes, anything else?
Within 30 days, man.
30 days is already there in the
It has been submitted by Mr. I. Saikia that the period for consideration of an application for grant of NOC is 30 days, and which is also supported by Mr. Sharma, saying that the limitation exists in the book of law.
Lords.
Read petition accordingly disposed of. Anything else? Yes.
Add online, my lord, Lordship, that within that period, he
So
considered.
that is what said that you have made a
Yes, yes.
submission and he has supported it
Yes.
because it exists in the book of law.
That
Yes.
that line would have been helpful.
No, Lordship, that 30 days is already there. If it is, he has to give a reason. If we cannot comply the order, that within that 30 days cannot give him the NOC, he has to give a reason. It's already there in the
If
act.
there is a reason, you have a ground of challenge. And if it is an NOC,
Lordship, I observed
Happy-
that, my lord, consideration to be made within that period of 30 days.
Again, that 3 word, Lordship.
yes. এটা থেকে দেন। তিনটা। Yes, sir, you were there. Sorry.
Much okay.
Mr. Kumar,
In this case,
which matter?
14.
Item 14. Is for. Huh? Senior
What has happened in this matter? There is a specific direction of this court. to
I,
release-
I am in a little hurry today, so if it can wait for,
Yes, madam. Wednesday next or Thursday next? Thursday.
heard Mr. BD, this is item 14 we are saying, heard Mr. BD, Learned Council is paying for the.
Lordship, I am for response number 7, 8 and 9.
So it's paying for.
Thursday.
Huh? List
Thursday.
matter again on, in the next week,
Thursday also.
on next Thursday, koi diyo. On the 13th of, on the 13th of November, 2025. Yes, sir.
We have filed a writ appeal in this case.
Thursday fixed price, Thursday.
Thursday, it is fixed on Thursday, no orders are being passed today.
Because you have mentioned it for Tuesday in the division bench, the writ appeal.
We have kept it for Thursday.
My lords, always.
Yes, Mr.
Let it be on Friday, my lord. Item
Which
number
matter?
23.
Item number 23.
That excise, that license, my lord, on IMFL, my lord.
Oh, yes, they were not giving it. You have any instructions on that?
My lord, another line of argument we will adopt, my lords, but
Then we can take it up on 25th maybe.
25th.
Huh? We'll say awaiting your
25th.
instructions or what?
Well, 25th is too long, my lord.
No, if you want.
They are not against us, they are withholding. Your lordship has asked where
Yes,
is
my
the
lords.
provision?
No, now we have a different issue altogether because it's only grant, it's not sanction. So there's a subtle difference, vast difference.
You are cancelling. You should cancel.
Grant and sanction are two different things.
তোমরা অহা 2 সপ্তাহের ভিতরে তোমরা ডেটটা দিয়েছো যে কি করতে লাগে because this bench will rise at 3 o'clock for the division bench. So
At
I
2
cannot-
o'clock, I
I cannot
can be there.
Huh?
I can be here at 2 o'clock. Your lordship is here.
I may also take some time to come back and sit down because I have got some other work to do. I may require some time.
Any other day. This way, that way, the matter should go, be concluded.
If you have it after the 24th, I can give you a date. If you want it
24th.
before that, I do not know.
Before that, not possible, man.
I am not here. Other benches will be here. Is it okay? Then we fix it on 17th, 18th, 19th, whatever you say.
Let
Last
it be
order
on
to PS level.
Let it be on 25th, man.
25th, yes. List this matter.
Because your lordship has heard the matter, only that law point. is-
List this matter again on the 25th of November 2025 as a part of matter.
Yes. Yes, lordship has heard, only I'll point out 1 or 2 cases.
আৰু বাকি orders আছে না?
My lord, in production list, my lord, I have to submit the written submission.
You can just submit the returns.
My-
We are passing on a production list of production list item. Just take down. Production list 1 item will be the learned council for the parties have submitted their written submissions. Stop. Hearing concluded. Hearing concluded, judgment is out. And other matters we'll see.
The matter regarding my recovery of, my notice was served for recovery of provident fund amount, my lord, after 15 years, my lord, and to a educational institution, private education, without deciding the jurisdictional question, whether it comes within the jurisdiction of the act, my lord. So it will require some time, my lord.
Educational institution, what kind of an educational
It's
institution?
a private school, my lord.
Private school,
That was established at that point of time for class 1 to 4. And thereafter it was in 2014, I think, my lord, that was closed. Now, after 15 years, my lord, they issued a notice, my lord, of the mark.
2014, the school was closed.
Yes, yes.
And then the PF wants you to,
PF, that was
where is that impugned order? Can you show us?
impugned order, my lord. This is the second time we have come, page 62. They were directed to pass a speaking order, my lord. Page 62 is the order, but last portion your lordship will find, page 69. They have already, my lord, disposed of the writ petition, which was already disposed of by this honorable court. Page 69, my lord. Last 4 line. They were directed to pass speaking order, taking into consideration jurisdictional aspect. But they, instead of doing that, they dispose of the writ petition, which was already disposed of by this honorable.
They are disposing of a writ petition saying that it is without jurisdiction. No.
It's
No,
not
no.
the fact actually. I'll coming. to
And
your-
prima facie,
There are reasons.
Petitioner submit his part, your lordship.
but other facts, your law point and other thing, it will take some time, your lordship.
Now, a small submission on my part.
Yes, yes.
Lordship may kindly peruse order dated 19/9/2025. The actual prayer part in the present writ petition is your lordship,
What is 19.8?
19/8/2025, passed by this honorable court. The primary ground of challenge is that the activity carried out by the petitioner would not fall under the scheme. So a gadget notification that has been mentioned in our affidavit. As per the affidavit, this institution falls under the category column 3 and 6 of that specific notification. Now, the next date, your lordship, that is 21/8/2025.
Yes. They were, you were required to file an affidavit.
Yes, I have submitted my instruction as per your lordship order on the last date. And based on those document, this honorable court came to a finding even the writ petition is not even maintainable, your lordship. That was the observation of this honorable court.
No, that was
Now,
gone into merit.
this connection, we have filed our additional affidavit.
They were required to file an affidavit in reply.
Yes.
That has come on record, yes.
That has come on record, my lord. And
We have filed an additional affidavit on 6/10/2025. In that additional affidavit, we have bring forth some of the documents. Prima facie prayer of the petitioner in their writ petition is that apart from the factual grounds, your lordship, whether the act is applicable over the establishment of the petitioner. Your lordship, if your lordship kindly peruse the steps, prayer part of the writ petition, your lordship. Page 23. Keeping aside the factual parts, your lordship.
no, we have filed our
It is
reply.
It is therefore prayed that your lordship would be pleased to call for record so and so as to why the impugned order dated 10/7/2015 passed by the recovery officer, Sub-Regional Office Tinsukia, purportedly in compliance of the
order dated so-and-so, passed in WBC so-and-so, shall not be quashed as further as to why the respondent shall not be directed to decide first as to whether the nature of employment of the employees of the Jyoti Vidyapith affects the provisions of the Employees Provident Fund and Miscellaneous Provision Act before proceeding further as to the liabilities. In this connection, Your Lordship, we have filed our additional affidavit bringing into record the notification at annexure to page 119, Your Lordship. First, prima facie is about the jurisdiction, because after affidavit in opposition that has been filed in back 18 or probably in the year 18,
There are two.
they have their contention, the petitioner's side contention is prima facie the jurisdiction part is to be decided. Now, in our additional affidavit, we have stated, that is the page 119, that para 3 of my additional affidavit, that the petitioner establishment so-and-so is an English medium school.
Okay,
Has
page
engaged,
92, Roman 3, yes.
yes,
Then,
3 and 6, Your Lordship.
Mm.
Now it falls under 3 and 6. Thereafter, Your Lordship, regarding the impugned order, Your Lordship, there is an annexure 117, that is issued on 10/6/1999, Lordship.
Mm.
That on that very time, the school was running as per the provisions of section, Lordship, that falls under,
You gave them a notice, yes, in 1999, yes.
along with a code, Your Lordship.
Mm.
Now, the code was of the query that whether it falls under falls under the category of a private school. In that respect, Lordship, we have even submitted that the school is presently carrying its business, having an that is annexed, Your Lordship, may kindly peruse.
What is the demanded amount?
3 lakh.
3 lakh something, my lord.
Yeah.
For the period 1999.
Now, what the petitioners challenge in this connection is an ex parte order has been passed, 30/12/2014. So thereafter, a demand notice has been set, and that is also without notice, and the lapse of 15 years has passed by. But in our affidavit in opposition, we have detailed, we have given our reply in detail that within that period, we have sent more than almost 23 numbers of notices. Your Lordship may kindly see the,
Is there a stay here?
yes, there is a stay operated.
Notice were not received by us. We have categorically stating, my lord,
You have
their own 2 affidavits, sir.
Once you appear in the matter before the inquiry committee, thereafter is any notice required?
No, for final hearing, my lord, they have mentioned a date, my lord. Final hearing, no date was given. That is our contention. And that contention is,
So why don't you hear them once? Where is the difficulty?
my lord,
because statutory provisions are always applicable.
We will see whether the EPF is EPF Act is applicable to these institutions
Yes,
or
yes,
not.
but-
That question we will decide.
That
that
is
question-
In
specific-
case we decide that it is applicable,
Yes.
then all you will have is an opportunity to
yes, yes.
appear.
Yes.
But that is the
Giving,
main issue.
letting bygones be bygones. They will have an opportunity to appear, pass your order.
That actually, it will work out.
But she may fix a date, my lord, we will satisfy on both the,
Because in this connection,
on the notice also, my lord, and all this.
we have even 23 numbers of notices we have sent, Your Lordship. Even the petitioner side, one day,
We have given reply to that.
admitted they are ready
We
to,
have replied to their notices, my lord, and that is no proof of.
and in the affidavit in reply, there is
First
nothing.
time they have
Do you notice what is happening here?
In-
Just a minute, madam, just a minute. Do you notice what is happening here?
Lordship.
I'm going like this and you two
Yes.
people are questioning and answering each other.
If Your
It does not
Lordship-
go on like
Notice
this.
is not the issue.
One
my
at a
lord.
time.
Yes, notice is not the issue.
So now you want this matter to be fixed on a certain date with some
Yes,
time
yes,
so
Your
that we
Lordship.
can take up the matter
Both
for a
the
final
parties.
disposal. Both the parties are on. Yes. Heard Mr. Swanson, Mr. You are Mr. C. Burwa.
B. Borough.
B. Burwa, sorry. Heard Mr. P. Burwa and considering the petition, I also heard Mr. Appearing for the
all the respondents.
For all the respondents. This matter relates to a demand raised by the Employees Provident Fund against the petitioner for payment of the dues for the year 1999.
From the year 1999 to March 2004.
To the,
Period is
from
April
1999 to March 2004,
Four.
full stop. Pleadings in the matter have been completed, full stop, and the matter was listed today for hearing. However, due to paucity of time and also at the request of the learned counsel for the parties, list this matter again in the second week of December on a hearing day for disposal.
Interim order may be.
Interim order passed earlier shall continue till the next date of list.
Contractual matter will take some time, Madam. Lordship is possibly rising. Lordship is rising.
Oh, they have confiscated your earnest money yet?
Yeah. And no, that is confiscated and asked us to pay more, my lord. 16 lakhs to deposit.
They have kept your security money and earnest money and also thereafter asking you to deposit another 57 lakhs.
They understood the matter. Finally, they said that, okay, we are clearing your bill. They have cleared the bill in 2019. Thereafter, there are some audit objection and state way, everything reversed, madam. That is the thing, madam. The municipal building was to be constructed in Block A and Block B. The Block B, I have completed. Block A, they were running their own office. They could not hand over to me. After the time elapsed, my lord, I said that there has to be some escalation, otherwise I cannot do this work in the earlier rate. That is the issue, my lord. Ultimately, giving me a personal hearing, municipal board said, okay, we've understood your thing, take your all bills, everything cleared, but earnest money and this thing was security deposit held. Finally, this interim order, this impugned order has been passed in 2020, saying that there's some audit objection, you have not done your job, so penalty.
All the pleadings are complete.
Pleading. Some date somewhere, madam.
Mr. Dotto, can we have it on another day? I have to rise at 2:50.
Oh, your lordship is rising.
There's a division bench.
Oh, yes, then it's okay, my lord. Any date convenient to your lordship?
A hearing day.
Well, not in the next week, my lord. I'll be away from Guwahati.
No, we'll say after 2 weeks on a date to be fixed by the registry.
That's better.
But Mr. B. Chakraborty, learned counsel for the petitioner, also but Mr. S. Dotto, learned senior counsel, appearing for the respondent number 2 and 3, assisted by
S.
Mushahari, learned counsel. Stop. The pleadings in this matter are complete. However, due to paucity of time, as this court has to rise, list this matter again after 2 weeks on a date to be fixed by the registry for hearing.
Much of it.
Yes, Mr. Gupta.
My lord, the matter, my lord, may require some time, my lord. Also,
what is it about?
My lord, this is about, my lord, the petitioners before lordship are senior citizens. And my lord, certain amount, the money has been, my lord, fraudulently siphoned away by the fraudster from their account. And my lord, we are, my lord, alleging that there is a negligence on the part of the SBI. My lord, due to which this fraud has happened.
The order of the ombudsman is under.
So, my lord, we have approached the ombudsman. My lord, the banking ombudsman for certain period, my lord,
they have allowed my complaint and refunded the amount. But the period on which, my lord, mainly huge amount transactions were taken place, my lord, those period, my lord, the ombudsman refused to give the amount because of the reason that, my lord, we have not approached the SBI within 3 days of the fraud. Now, there is an RBI circular which says
There
if
is a certain
within 3
time
days
there.
you approach.
I think RBI regulations.
Regulation is there.
Approaching RBI.
I think it is 3 days for the full refund, then 7 days,
Yes.
leaving it to the discretion of the bank
Yes.
to do whatever it wants.
But our contention is, when we approached within 3 days.
Oh.
We even
Another clause saying that if the fault is on the part of the customer.
If the ombudsman has said that he has not approached within 3 days
No, not 3
and
days.
he has approached, then the matter
Their
will be.
contention is that they approached on 2/6/2021. SBI says that they approached on 4th. From 4th to 9th, there is some transaction. So from the date of information, RBI has directed the SBI to refund. From 2 to 4, they have stated that they informed the SBI, they refused. That is the issue.
But that's a question of fact.
Mild. That is the question of fact.
My lord, 4 to 9, my lord. The transaction,
That has been-
transaction period is 1st June 2021 to 9 June. According to our stand is that, my lord, he informed us bank to, my lord, on 4th, my lord.
On 4th.
As per the RBI circular 17 says that, first says that if any, my lord, fault of the part of the.
So
petitioner-
4th to 9, whatever transaction took
Yes,
place, that
that
has
has
been
been refunded.
refunded.
That, my lord, he
And
informed-
1st to 3rd, whatever transaction that it has been.
Yes,
deleted.
he
and in
informed
fact
us
on-
and according to us, my lord, on 4th.
And he says that
We
he.
have not hold that, my lord, that account. That is our fault, my lord. Up to 9, my lord, there is 1,34,600 rupees was, my lord, withdrawn for start, my lord. Then advisory note of the ombudsman says that you refunded that. We have refunded. Now he takes, my lord, stand that I have informed from 1 to 4 that period.
How do you say you informed it from 1 to 4? That
Yes,
period
sir.
also you had informed. Where did you say that? When
Well-
was your first information given? We are just trying to, we cannot dispose the matter.
Basically, take a stand there, let them prove that he has informed to the bank on 1st day or up to 4th, my lord. As per our trial mail, my lord, on 4th he informed, my lord. And that is the stand, my lord.
Let him just find
Page-
out if he can.
Page 29, my lord.
29, yes.
Page 29 is the, my lord,
Transaction.
this is the online bank statement given by the bank
Mhm.
on immediately on the second day, my lord. First, all the main transactions, my lord, where major amounts were fraudulently siphoned took place on 1st of June. Immediately on 1st of June, my lord, I have lodged a complaint before.
How? That is what we asked.
First, we have lodged an FIR, my lord, and this is on the page 29, my lord. We have approached the bank on 2nd of June, but, my lord, the applicants could not, my lord, retain the receipt or the acknowledgement. But, my lord, this statement which is there before my lordship, my lord, will see the account statement from 1st June to 1st June. Now, this is, my lord, I have, the petitioners, my lord, never activated online banking. My lord, they had never activated, and it's a matter of record
Okay.
that they had no internet banking. Now, this is the internet banking
If
statement
that facility had not been activated by you, how come they?
the bank has given. That is
Whether
exactly.
you are required to give a notice for that at all or not is your case.
No, this information was given by the bank on 2nd June.
That has been changed by the fraudster. Whether
No,
the
no,
message
my
of
lord.
That is also another issue.
My lord, the fraudster has sent that mobile number. No, my lord.
We will come, my lord, Lordship will fix a date, my lord.
My lord, before this, my lord, next, my lord, he sends it anyway, my lord.
We are just trying to find out what
Yes.
could be the case.
Yes. Hello,
Lordship will fix a date.
my lord.
Yeah, fixing a date would be not possible. What we will do is we'll fix the week and then alarm. Beautiful alarm. Yes. Due to paucity of time, the matter could not be taken up for disposal today. At the request of the council for the parties, list this matter again after 2 weeks on a date to be fixed by the registry. Stop. That should do.
My lord, that. There is one 455.
Sorry?
I'm referring to the respondent before.
You take down the attendance. Mr. H. Gupta, Learned Counsel appearing for the petitioner.
I'm for 1, 2, and 3.
C appears for the 1, 2, and 3, and Mr. K. Das appears for 4 and 5. P. Hazarika 1, 2, and 3.
1, 2, and 3.
Okay. I'll go take the.